have worked to build a nation of widening opportunities. Now, our generation of Americans has been called on to continue the unending search for justice within our own borders. We can understand how this all happened, but it cannot continue.
We must say, wake up, America, wake up, for we cannot stop.
When you see something that is not right, not fair, not just, say something, do something.
We believe that all men are entitled to the blessings of liberty.
We hold these truths
to be self-evident that all men are created equal.
Yet millions are being deprived of those blessings.
Legislative measures limiting ballot access are now moving through 47 state houses right now.
The new law, for example, prevents anyone but a poll worker from handing out water or food to voters waiting in those notoriously long lines that are much more common in counties with larger black and brown populations.
And look throughout history, and you will know that what is taking place today is a new
Jim Crow in a suit and tie.
We all know that this is not a Democratic or Republican issue. It is an American one.
We have got to have federal protections.
The John Lewis Voting Rights Act.
To make sure that we are expanding the protection of voters, the right to vote in this country.
And I will fight until the death to make sure every citizen has that right to vote.
If not us, then who? If not now, then when? The arc of the Warren universe is so long, but it bend toward justice.
It is deadly wrong to deny any of your fellow Americans the right to vote in this country.
Our work is not finished.
Since our nation's founding, there's been an intractable conflict between champions of democracy and defenders of white supremacy. In 1890, white supremacists won a victory that would inspire a generation of legislation to deny full citizenship to black Americans. They called it the Mississippi Plan. Historian Carol Anderson, who's one of today's witnesses, has described it as, quote, a dizzying array of poll taxes, literacy tests, understanding clauses, newfangled voter registration rules, good character clauses, all intentionally racially discriminatory but dressed up in the garb of bringing integrity to voting. The president of the state constitutional convention that spawned the Mississippi Plan, S.S. Calhoun, announced, and I quote, "Let's tell the truth if it burst the bottom of the universe. We came here to exclude the Negro. Nothing short of this will answer." And they succeeded. 3 years later, a local newspaper reported that about 94% of black men in Mississippi who were eligible to vote under the old Constitution would no longer be eligible under new rules. In the words of one reporter, it marked, quote, practical elimination of the majority race from the politics of the state. What happened in Mississippi did not stay in Mississippi. By 1910, states including South Carolina, Louisiana, North Carolina, Alabama, Virginia, Georgia, and Oklahoma had adopted statutes that sought to emulate Mississippi's success in systematically suppressing black voters. By the late 20th century, the federal government recognized these laws, passed during the Jim Crow era, amounted to a national crisis of voter disenfranchisement. Many of the most egregious voter suppression tactics were outlawed by civil rights legislation in the 1960s. But the insidious effort to suppress the right of voters of color has evolved and continued, most recently through a scourge of voter suppression laws introduced in state capitals across America. Just this year, more than 360 bills with restrictive voting provisions have been introduced in 47 states. These new pieces of legislation may not involve literacy tests or counting the number of jelly beans in a jar like the original Jim Crow, but make no mistake, they are a deliberate effort to suppress voters of color. This is the reality of our political landscape following the Supreme Court's Shelby County versus Holder decision in 2013, which gutted the Voting Rights Act. Some of the new proposed laws requires voters to show ID and cut back early voting. One Texas bill would make it a felony for election officials to distribute absentee ballot applications. The law that's received the most attention in recent weeks is the one that Georgia's governor signed last month. It'll make it harder for Georgians to vote early or by absentee ballot, and make it a crime to offer water to voters waiting in line. It wasn't long ago that an American could be barred from voting for failing to guess the number of jelly beans in a jar. Now they might not be able to vote because they're stuck in a lengthy line on a hot day, and they can't even receive a drink of water from a Good Samaritan. Why are states like Georgia making it harder for Americans to exercise our most fundamental right? The response from proponents of these laws is that they help maintain the integrity of the election system, another tactic taken straight from the Mississippi Plan playbook. But President Trump's officials at the Department of Homeland Security declared that the 2020 election was the most secure election in American history. Some of my colleagues on this committee were on the same ballot as President Trump, and they're willing to accept the results that showed their re-elections valid. So if our elections are secure, these laws aren't really about integrity. What is the problem that lawmakers in Georgia want to address with the new law? The problem is obvious. Too many voters are showing up. Georgia law saw historic voter turnout during the last election. Among Georgia voters who returned absentee ballots, we get an answer to our question. 65% of those who returned absentee ballots voted for President Biden, 35% for Donald Trump. It seems Republican lawmakers in Georgia have concluded that the solution to their election problems is to make it harder to vote, because the voters who did vote in the last election were not their voters. That is fundamentally un-American. In the words of Senator Warnock, and thank you for joining us today, it is democracy in reverse. In our republic, politicians don't choose our voters, the voters choose us. We ought to enact legislation that makes it easy as possible to vote while ensuring our elections are safe and secure. There are a number of steps Congress can take to advance this goal, like the John Lewis Voting Rights Advancement Act, and enshrining an affirmative right to vote in the United States Constitution. I went back today to read the transcript and the reporting of the transcript of the January 2nd telephone conversation between President Donald Trump and Secretary of State of Georgia, Mr. Raffensperger. It was recorded. There is no doubt what was said in that conversation. The President of the United States, Donald Trump, was explicit. Here's what he said. I just want to find 11,780 votes, which is one more than we have. The president, who had 17 days left in his administration, hinted that Mr. Raffensperger and Ryan Germany, the chief lawyer of the Secretary of State's office, could be prosecuted criminally if they did not do his bidding. Here's what the president said. You know what they did, and you're not reporting it, he said. You know that's a criminal offense, and you know you can't let this happen. That's a big risk to you and to Ryan, your lawyer. That's a big risk, the President of the United States said in a conversation that was recorded. It's no surprise that this president goes on to claim not only several conspiracy theories, including debunked charges that ballots in Fulton County, Georgia were shredded, that voting machines were operated by Dominion voting systems tampered with and replaced. And Mr. Germany in this conversation can be heard telling the president that such charges are flatly untrue, even as Trump insists otherwise. You want to have an accurate election, and you're a Republican, Mr. Trump told Mr. Raffensperger. Mr. Raffensperger replied, we believe that we do have an accurate election. Trump responded, no, you don't have, not even close. You guys are off by hundreds of thousands of votes. I reread that to think for a moment about this state election official, Mr. Raffensperger in Georgia, who had the foresight to tape that conversation so that history would be clear, but also made it clear that an election where nearly 5 million votes were cast, the notion that they could find 11,780 votes as President Trump requested, was just plain wrong. Of all the absentee votes, of all the votes in person, of all the activities that took place before and after the election, Raffensperger refused to concede that point. Well, I can tell you it cost him, because when it came time to pass the new laws, the Georgia legislature, signed into law by the Georgia governor, stripped the Secretary of State, Mr. Raffensperger's position, of his power to preside over the state election board. He paid a heavy price for being honest and courageous in that conversation with President Trump. The Secretary of State is also removed under this new Georgia law as a voting member of the state election board. Clearly, a majority of those who voted in the Georgia legislature were out to send Mr. Raffensperger a message that if you don't take the Trump line and follow it and allege that you found some votes that weren't counted or counted improperly, you'll pay a price for it. That is what we're up against here, and that's why this hearing is taking place. One of my heroes and friends and former colleagues, John Lewis, said, "The vote is precious. It is almost sacred. It's the most powerful, nonviolent tool in a democracy." Well, recent efforts to prevent Americans from participating in our democracy remind us how much work remains to protect this precious, almost sacred right. Now I'll turn to Ranking Member Grassley for his opening remarks.
Thank you, Mr. Chairman. Now, we all know this is supposed to be a hearing about voting rights. Unfortunately, it's just the latest attack on one of our states for enacting election integrity laws. Pretty simple. National Democrats and big business have colluded to bully Georgia in retaliation for its new voting laws. But we'd be naive to think that they'll stop with the Peach State. Indeed, many of Georgia's new provisions are similar to those that we have in my state of Iowa, where we've experienced a record turnout and recently no instances of anyone being hindered from voting. I object to the title of this hearing. Like others on this committee, I'm a fan of history. I try to learn from it. I don't use it to insult my opponents. As I said, the title of this hearing is offensive. And as a student of history, this title diminishes the very real challenges and unfairness that minorities endured in the Jim Crow South at the hands of Southern Democrats. The right to vote should not be political. We should all agree that participating in America's democracy at the ballot box is a fundamental right. It's a right we should want to protect, and it should not become a political football. At a time when voters on both sides of the aisle have doubts about the integrity of our elections, polarizing rhetoric distorts history is not helpful. I'm eager to hear from Congressman Owens what he thinks about these comparisons of voter ID requirements to the evil system of legalized racial oppression in which he grew up. There's a lot of falsehoods being peddled about the new Georgia law. When President Biden repeatedly said that Georgia ended voting hours early, the liberal Washington Post gave him 4 Pinocchios in his fact check. Their fact checker was shocked that after the 4 Pinocchios, Biden kept repeating the same false claims. It goes to show that these claims about Georgia aren't about truth, they're about politics. And it goes beyond politics. The concerted efforts of liberals and their allies to mislead about Georgia's voting laws have had terrible effects on Georgia itself. There's an organized campaign started to make big business punish the people of Georgia for their political choices. When you make political comments and it hurts people's pocketbooks, it ought to be something everybody be offended by. Most infamously, Major League Baseball moved the All-Star game from Atlanta, a move that's likely to cost the city's economy 100 million jobs, and that's affecting the income of Georgians and probably some jobs in Georgia. A state senator lost his job at a prominent law firm after political activists took a break from fleecing their donors to get him fired for his work as a citizen legislator. When partisans and companies collude to ruin the livelihoods of their opponents, there's a term for that. It's economic terrorism. The American people don't like this. A recent NPR poll asked whether people support or oppose professional sports using their public roles, positions, and events to influence politics. 55% opposed it, only 40% supported it. On the other hand, the American people do like secure elections. A recent poll showed that 77% of the Americans support voter ID laws, including 74% of the independents. 66% even support voter ID for absentee ballots. 80% agree that states need to balance no-excuse voting with election integrity safeguards. 93% say that the voter registration rolls should be accurately maintained, with 83% saying states should remove old registers. I don't get it when we hear, not just in Georgia, but other states, that there's something wrong when somebody died, that they ought to be removed from the voting rolls. In 2021, I'm not sure that apple pie would poll as well as the common sense election integrity. I can tell you the people of Iowa, whom I represent, like secure elections. That's why we recently passed laws to do just that. I have a statement for the record from our Secretary of State explaining how we work to make election laws easy and honest. This last election showed why secure elections are necessary. We'll be hearing from our Democrat friends that voter fraud is so rare that we don't need to take steps to prevent it. But in Iowa, 2nd District, Representative Marianne Miller Meeks won a race last fall by just 6 votes. That's 6. Every vote counts in Iowa, which means they better be legitimate. In fact, during each election in Iowa, we find numerous instances of double voting. It's not a big number, but it does happen. And with congressional races being decided by only 6 votes, it obviously matters. At the same time, I want to be clear. There's no evidence of anyone being unable to vote in Iowa due to our voting security provisions. All this talk about the importance of voting from Democrats is less than amusing. Just last month, Speaker Pelosi tried to use the power of her majority to throw Dr. Miller Meeks out of the House 2nd District in Iowa, even though her election was fully certified. It was fully certified by a committee of 3 elected Republicans and 2 elected Democrats. Her opponent didn't want to admit she lost, but she skipped court, and Democrat super lawyer, who, by the way, is facing sanctions in Texas, tried to change the results of the House instead. When people will stop at nothing to win races, it's more important than ever that our election laws be secure. Sadly, my friends on the other side seem to disagree. Elections and voting legislation that's been proposed in Congress will take away the ability of states to establish their own voting rules. I hope to hear from Secretary Gardner why it's so important for states like Iowa, New Hampshire, and Georgia to manage their own elections, and why federalized election rules are bad for election integrity and for voter participation. I hope to hear from President Pro Tem Jones about what really happened in Georgia, not the made-for-TV headlines about Jim Crow 2021, but a sensible, fair, common-sense effort that they made to increase voter confidence in their election. Basic claims of voter suppression are just as corrosive to our democracy as baseless claims of voter fraud. And we heard too much about that from last November. We should all be committed to making elections accessible and secure to maintain the confidence of the voters. And when I hear about voter suppression,
And the loser in this election lost by more, with more votes than anybody loser ever in the history of the country got. And the winner won by more than any winner in the history of elections. And you're telling me about voter suppression, the way people turn out? Give me a break.
Thank you, Senator Grassley. We're speaking about what happened since that election in state legislatures across the country. Since 2014, Senator Leahy has led the efforts in the Senate to restore the Voting Rights Act. Due to a conflict with the Appropriations Committee hearing this morning, he may not be able to question witnesses, but he's asked to make opening remarks, and I'm going to extend the same courtesy to Senator Cornyn after Senator Leahy is finished. Senator Leahy.
Well, thank you, Mr. Chairman, and I do appreciate the courtesy. I think it's excellent that you're holding this timely hearing. I think this is the greatest crisis facing our democracy today. I look at my own state of Vermont, where everybody can vote, is encouraged to vote. We do everything possible to vote. We elect a Republican governor and a Democratic lieutenant governor. Every vote counts, and we make sure they do. And people in my state look at what happened in the Georgia legislature. They cannot understand that is happening in the 21st century. You know, the 2020 election should be a great source of pride for our nation. We suffered through a deadly pandemic, but even so, more Americans voted in 2020 than in any modern time in modern history, both Republicans and Democrats. But instead of celebrating that significant achievement, the former president mounted a campaign of misinformation, spreading the big lie that widespread voter fraud led to his defeat. And his disinformation campaign led directly to the violent assault on the nation's capital that took the lives of 5 Americans. I was proud when Republicans and Democrats in Congress stood bravely together amid the broken glass in ransacked offices to reject the former president's big lie. I was proud that we crossed party lines to certify one of the most secure elections in our history. And when Republicans and Democrats came together again days later for the inauguration of President Biden, America sent a powerful message to the world. Neither a deadly pandemic nor a violent insurrection could defeat our American system of self-government. Now, that was just 90 days ago. But instead of capitalizing on measures that resulted in the highest voter turnout in over a century, dozens of states have moved forward to restrict access to the ballot. As of March, more than 360 bills have been introduced in state legislatures to make voting harder for Americans. These cynical efforts have been justified on the grounds it should be harder to cheat, which, of course, falsely implies that voter fraud was a widespread problem. Did we not just go through an election where there was virtually no evidence of voter fraud and it was looked at by the courts and that's the conclusion they came to? Did we not just reject a violent attempt to overturn our election based on the utterly false claim that was stolen through fraud? Now, I realize memories may be short, but this wave of voter suppression laws is premised on a little bit more than the big lie with a slapdash paint job. If you rejected the big lie then, you should oppose these efforts today. We should all easily agree that when any voters in any party are disenfranchised, our democracy suffers. Depriving Americans of the foundational right to vote also denies them representation in our democratic republic. It's exactly why the 1965 Voting Rights Act, which helps the federal government prevent voter disenfranchisement, has been bipartisan. Every Congress from 1965 to 2006 repeatedly reauthorized the Voting Rights Act on a bipartisan basis, including in our body, Mr. Chairman, in 2006, by a vote of 98-0. Now, among those who joined me in voting yes in 2006 were Ranking Members Grassley, Senator Graham, Senator Cornyn. The reason the Voting Rights Act has always been a bipartisan bill is it's pro-democracy, not pro-Republican or pro-Democrat. So I hope will be increased support for the already bipartisan John Lewis Voting Rights Advancement Act. It just restores the federal government's powers under the Voting Rights Act. Without Section 5 powers, which my dear and close friend John Lewis, a hero to many, called the heart and soul of the Voting Rights Act, no administration of either party has the necessary tools to prevent states from enacting changes making voting more difficult for Americans. And as we watch almost daily states unleash a wave of ill-founded laws that restrict the precious right to vote, not protect it, but restrict it. The oversight role of the federal government envisioned by the 1965 Voting Rights Act is more urgently needed than ever. All of us, Republicans and Democrats, should remember what we saw and how we felt on January 6th. We should all recall casting our votes in the twilight hours of January 7th in our Capitol, the seat of our government that bore the fresh wounds of a violent attack that sought to deny the American people's will. On that day, we put aside our partisan differences in defense of something much bigger than political party, our democracy itself. In the months ahead, Mr. Chairman, I hope we can answer that same call to defend our sacred right to vote, the right that gives democracy its name. Thank you.
Thank you, Senator Leahy. Senator Cornyn.
Thank you, Senator Durbin and Senator Grassley, for holding this important hearing today. This is an important topic, but I don't think we do justice to this topic by entitling this Jim Crow 2021. Unfortunately, rather than the usual oversight and fact-finding and legislating process, it looks like today's hearing is really just performance art in order to enhance a false narrative about how far we've come in this country, thank goodness, when it comes to minority voting rights participation. The right to cast a ballot, of course, is the cornerstone of our democracy. It's the process through which the will of the people is heard and turned into action. The very basis for the legitimacy of our laws is the consent of the governed, and they consent by electing their public officials at the ballot box. I believe our standard should be that we should make it easier to vote legally in America, but also at the same time make it harder to vote illegally. Well, sadly, the right to vote was denied to a generation of Americans based solely on their gender or race. This type of discrimination stands in stark contrast to the founding principles of our country. And I hope I can speak on behalf of everyone in this room when I say we need more Americans to participate in our democracy, not fewer. In Texas in 2020, we had a historic turnout of registered voters, 66% of registered voters of all ethnicities and race. Just as Americans have a right to make their voices heard in our elections, Congress has a responsibility to make sure those elections are fair and free. If we don't have fair and free elections, we don't preserve the core constitutional right of the people to make their voices heard through the ballot box. Expanding voter access does not have to come at the expense of common sense guardrails and protections that preserve the integrity of the ballot. For every one person who votes who is unauthorized or is disqualified to vote, that dilutes the vote of legitimate and legal voters. And disparaging those same common sense protections like voter identification as Jim Crow 2021, or in other words, racist, is false and I believe dangerously so. Our founders understood that all power ultimately resides in the hands of the people. When government takes its power away from state legislators, it is effectively seizing power from the people of those states to hold their elected officials responsible. This is very important because our founders gave us a roadmap, in other words, the Constitution, as to the power residing in the hands of the people through their ability to hold their state legislators accountable. Article 1, Section 4 explicitly gives the states the power to regulate, quote, the times, places, and manner of holding elections, close quote. Congress may, however, quote, at any time, make or alter such regulations except as to the place of choosing senators. I read this to mean that the states are to chart their own course for elections, subject to guardrails, and where necessary, Congress can provide additional guidance, but cannot hijack the process entirely. Nowhere in the Constitution does it empower the federal government to completely usurp the role of the states in holding elections. Indeed, nowhere does the Congress have the authority in one of its enumerated powers, as reflected in Article 1, Section 8 of the Constitution. In a recent gerrymandering case, Chief Justice Roberts noted that the framers assigned the issue to the state legislatures, expressly checked and balanced by the federal Congress. Yet through H.R. 1, Congress is not acting as a check. It's acting like a hijacker to take over the constitutional authority from the states and acting as the sole arbiter as how an election is run in rural Vermont or downtown Chicago. This past election, for example, we had the highest turnout ever in a presidential election. According to network exit polls, the number or percentage of African Americans who cast their ballot is roughly the same as the percentage of the African American population in America. I'm encouraged by this trend of more people voting and hope it continues. I agree we should have this hearing and we should look at appropriate bipartisan solutions to improve voter access. But using charged rhetoric to describe aspects of state voting laws like the one in Georgia is misleading. It's not constructive, and it undermines public trust in Congress and in our election system. In fact, as we've learned, the Georgia law comports with the existing laws of many Democrat-run states and also reflects the safeguards supported by the bipartisan Carter-Baker Commission. This is not to say that there's not more work to be done, but it is important that we temper the charged rhetoric and understand the specifics that we're actually talking about, rather than jumping headfirst into this debate across the country in a rush to judgment. Here's just one example. The Georgia provision requires a free ID card in order to receive an absentee ballot. That's nearly identical to the provision in the 2002 bipartisan bill supported by then Senator Biden and the current chairman of this committee. Indeed, the Help America Vote Act would have required everyone voting in a federal election to provide a copy of a photo ID. And if they don't have one, they can get one or provide a copy of the bank statement, paycheck, government document, or utility bill. In other words, they can do it for free. I don't think this is a radical proposition to suggest that voting identification coupled with the offering of free ID cards is a radical restriction on voting. It just doesn't hold up. To the contrary, it's a basic safeguard to preserve the right of people to vote and for their vote to count equally in a free and fair election. And this safeguard helps inspire public confidence at the same time. The Carter-Baker Commission, Jimmy Carter, James Baker III, named for them, looked at preserving the integrity of our elections, and they reached the same conclusion. The electoral system cannot inspire public confidence if no safeguards exist to deter or detect fraud or to confirm the identity of voters. Photo IDs are currently needed to board an airplane, to enter a federal building like this one, to operate a motor vehicle, to cash a check, to buy alcohol, and pick up will call tickets at the Major League Baseball games. I support efforts to expand voter access, but these efforts cannot interfere with the integrity of our elections. Today's hearing is an excellent opportunity to discuss that and expanding access to the ballot box for all eligible voters. I appreciate the chairman and ranking member holding this hearing. Not so much the title of the hearing, but I do think the subject matter is important, and I'm eager to hear more from today's distinguished witnesses.
Thanks, Senator Cornyn. Today we welcome two members of Congress to testify, Senator Reverend Raphael Warnock of Georgia and Congressman Burgess Owens of the 4th District of Utah. In addition to representing the state of Georgia after his election earlier this year, Senator Warnock serves as senior pastor of the historic Ebenezer Baptist Church in Atlanta, where our late colleague, Congressman John Lewis, was a member. Senator Warnock, could you please proceed with your statement?
Thank you, Chairman Durbin and Ranking Member Grassley and members of the committee for inviting me here today. I'm especially glad to join these distinguished witnesses. Mr. Chairman, I've come here today to stress the critical need for the federal government to act urgently to protect the sacred right to vote. America is a land where possibility is born of democracy. Our vote is our voice, a chance to help determine the direction of our country and our own destiny within it. Record numbers of Georgians used their voices and voted in the last election. And in response to this swell in Democratic participation, politicians in our state legislature responded not in celebration, but with retaliation. They could have gotten busy having not seen the outcome that some of them wanted. They could have gotten busy changing their message or adjusting their policy. Instead, they got busy changing the rules as if the democracy belongs to them and not the people. We've seen voter suppression bills since the election in November and January all across this country. 360 voter suppression bills in 47 states, an increase of 100 bills since I highlighted this issue on the Senate floor just a month ago. As of today, 5 of these bills, including in my own state of Georgia, have been signed into law. These efforts vary in exactly how they suppress voting. Some new laws, like in Georgia, will make it harder to vote by mail. Some will make lines that are already too long longer. Harder to cast a provisional vote. The new law also gives state politicians, some of the same politicians who still today refuse to acknowledge President Biden's lawful and decisive victory, the power to override local election officials. We may be tempted to dissect these bills as if analyzing them piece by piece makes them more rational. But that narrow analysis only obscures the larger, unmistakable picture. This is a full-fledged assault on voting rights, unlike anything we have seen since the era of Jim Crow. For all of their differences in exactly how they suppress the vote, what these bills all share is that they are predicated on the big lie, that the outcome of our last elections were the result of fraud, or at least the presidential election. I guess the members who won their elections are okay with that outcome. The truth is, politicians in their craven lust for power are willing to sacrifice our democracy by using the big lie as a pretext for their true aim. Some people don't want some people to vote. To be sure, we have seen these kinds of voter suppression tactics before, aimed at the same communities. They are part of a long and shameful history in Georgia and throughout our nation. But that history is also filled with moments of hope and promise, when our nation has come together in recognition that preserving our democracy is absolutely essential. Voting rights are preservative of all other rights. Just 15 years ago, the United States Congress reauthorized the Voting Rights Act of 1965 under a Republican president, and with a bipartisan vote in the Senate of 98-0. At the time, our colleague, Senator Mitch McConnell, praised its passage, declaring it a law that would make a difference for all of America. Many members of this committee, including the chair and the ranking member, enthusiastically voted in favor of it. That was 2006. Why shouldn't voting rights legislation be just as bipartisan now in 2021 as it was in 2006, voting rights should always be bipartisan. It is not the difference between right and left, but the difference between right and wrong. Many argue that the United States Senate is dysfunctional and incapable of governing in a bipartisan manner. We can boldly refute these claims by coming together not as Democrats or Republicans, but as supporters of democracy itself to pass the For the People Act and the John Lewis Voting Rights Advancement Act. Together, these two bills would turn the tide against state-level voter suppression proposals all across our country. These pieces of legislation would expand and protect access to the ballot for every citizen, Democrats, Republicans, and independents. Because strengthening our democracy does not benefit one party over another. Instead, democracy reform benefits all of us by ensuring that our government is of the people, by the people, and for the people. John Lewis was my parishioner. I was honored on many occasions to stand with him as we took people to vote after church at Ebenezer. He understood that our democracy transcends all else, and he nearly died on the Edmund Pettus Bridge defending it. Today, our country faces the most widespread assault on voting rights since that era. The four most powerful words in a democracy are "the people have spoken." The highest and most sacred action that the Senate can take is to protect the right of the people like it did in 1965. As we move forward in this discussion, I've asked myself on many occasions, what would have happened had we not passed federal legislation affirming the covenant of our democracy in 1965? Where would Georgia be? How would it prosper on the other side of a segregationist curtain? If we had not acted in 1965, what would our country look like? Surely I would not be sitting here, only the 11th black senator in the history of our country and the first black senator in Georgia. And maybe that's the point. It concerns me that some don't hear the irony in their statement that we must protect minority rights in the Senate while refusing to protect minority rights in the society. We've got to act. History is watching us. Our children are counting on us, and we must pass federal voting rights legislation no matter what.
Thank you, Senator Warnock. Senator Grassley, would you please introduce your guest?
It's a great pleasure to introduce him, and most people probably know him better as an outstanding NFL football player, but it's my pleasure to introduce Congressman Burgess Owens. Congressman Owens represents the great state of Utah, along with our colleagues, Senator Mike Lee and Romney. Congressman Owens is a new addition to the House, and we're so pleased to have him here with us this morning.
Thank you, Chairman Durbin, Ranking Member Grassley, and the members of the committee for the invitation to join you today at this hearing. My American story begins with my great-great-grandfather, Silas Burgess, who arrived in America as a child, shackled in the belly of a slave ship. Silas was sold on an auction block with his mother in Charleston, South Carolina, to the Burgess plantation. He escaped through the Underground Railroad and later became a successful entrepreneur, purchasing 102 acres of farmland paid off in 2 years. My grandfather, Oscar Kirby, served our country in World War I and was a respected and successful farmer, raising 12 children, all of them were graduating from college. My father, Clarence Burgess Owens Sr., was stationed in the Philippines at the end of World War II. When he returned home to Texas, actual Jim Crow laws denied him the postgraduate education. Raised in a generation that used this as motivation, he received his PhD in agronomy at Ohio State University and had a successful career as professor, researcher, and entrepreneur. I grew up in the era of actual legalized institutional racism. I grew up in the Deep South in Tallahassee, Florida, in the 1960s during the days of KKK, Jim Crow, and segregation. My first experience with white Americans was at 16 years old. At 18, I was the third black athlete to receive a scholarship to play football at the University of Miami. Now I proudly represent Utah's 4th Congressional District in the U.S. Congress. I sit today before you as someone who's lived the American dream, as have millions of other Americans of all races from every background. This is due to our country's mission statement that all men and women are created equal. A mission statement that every American should have the equal opportunity for life, liberty, and the pursuit of happiness. But as someone who's actually experienced Jim Crow laws, I'd like to set the record straight on the myth regarding the recently passed Georgia state law and why any comparison between this law and Jim Crow is absolutely outrageous. Here are a few examples of my own life of what Jim Crow laws actually look like. At the age of 12, my father allowed me to participate in a demonstration with college students in front of the segregated Florida State Theater, where because of our color, we could not enter. I was the youngest participant there. Only 50 years later did I learn that my father had parked across the street to watch and make sure I was safe. In the 7th grade, my school never received new books. Instead, we received books from the all-white school across town. At service stations, there were white men-only restrooms, white women-only restrooms, and a filthy restroom in the back of the station for Black Americans designated as colored. In addition, Jim Crow laws like poll tax, property tests, literacy tests, and violence and intimidation at the polls made it nearly impossible for Black Americans to vote. The section of the Georgia law that has brought so much outrage from the left simply requires any person applying for absentee ballot to include evidence of a government-issued ID on their application. If a voter does not have a driver's license or ID card, that voter can use a current utility bill, bank statement, government check, paycheck, or any other government document that shows a name and address of this voter. If a voter somehow cannot produce one of these above forms of ID, that voter can still vote and cast a vote, provisional ballot. By the way, 97% of Georgia voters already have a government-issued ID. What I find extremely offensive is the narrative from the left that Black people are not smart enough, not educated enough, not desirous enough for education to do what every other culture and race does in this country, get an ID. True racism is this. It's projection of the Democratic Party on my proud race. It's called the soft bigotry of low expectation. President Biden said of the Georgia law, this is Jim Crow on steroids. With all due respect, Mr. President, you know better. It is disgusting and offensive to compare the actual voter suppression and violence of that era that we grew up in with a state law that only asked that people show their ID. This is the type of fear-mongering I expect in the 1960s, not today. And by the way, literacy tests and poll tests were initiated by the Democratic Party. The intimidation of Black Americans by the KKK was initiated by the Democratic Party. Jim Crow, that I grew up in the South, of segregation, was initiated by the Democratic Party. The soft bigotry of low expectation now projected on Black Americans, not Italians, not Asians, not Polish, not Jewish, but only Black Americans, is being done by the Democratic Party. Where Black misery today thrives and is prevalent, lack of education, lack of jobs, high crimes, the call for defund the police is all done in Democratic parties. By increasing illegal votes and not giving voice to those legal Americans, Black Americans, who are seeing and waking up today is the real tragedy of this process. We're seeing 18% of Black men turn away from the Democratic Party because they're seeing that their vote can count and their future can matter. We're seeing twice the percentage of Black women doing the same. A record number of Hispanics, Asians, and gay community members doing the same. So no, all Americans expect, very simply, is fairness, security, to walk away from the poll booth knowing that my vote counted. If we didn't win, we work harder next time to make sure our message resonates. But to call this Jim Crow 2021 is an insult, my friends. For those who never lived Jim Crow, we are not in Jim Crow. And for Black Americans to go out every single day and vote the way we feel we should is a right that we should have and not being demeaned by something 60 years ago in which we had no right to do any of the above. Thank you very much.
We will now turn to our panel of witnesses. We thank the members for attending. Today, we welcome 5 witnesses to testify about the latest assault on the fundamental right to vote. I will introduce the majority witnesses, then I'll ask Senator Grassley to do the same for the minority witnesses. Our first witness is Professor Carol Anderson. She's the Charles Howard Candler Professor of African American Studies and Chair of African American Studies at Emory University in Atlanta. Professor Anderson's research focuses on public policy and the intersection of race, justice, and equality in the United States. She's the author of multiple books, including White Rage, The Unspoken Truth of Our Racial Divide, and One Person, No Vote, How Voter Suppression is Destroying Our Democracy. Sherilyn Ifill is well known to the committee and others. She's the president, director, counsel of the NAACP Legal Defense and Education Fund, a civil rights organization founded by Thurgood Marshall in 1940 that has led some of the most significant legal battles for racial justice and equality. She first joined LDF in 1988 and took over as director counselor in 2013. Finally, the Honorable Stacey Abrams, joining us from Atlanta. She served for 11 years in the Georgia House of Representatives, including 7 years as Democratic leader. In 2018, she became the first Black woman to be the gubernatorial nominee for the major party in the United States. After witnessing the voter suppression efforts during the 2018 election, she launched Fair Fight and Fair Fight Action to protect the voting rights of Georgians and other Americans. Ranking Member Grassley, would you please introduce your witnesses?
Yes, I'm going to introduce Speaker Pro Tem Jan Jones, and then Senator Cotton is going to introduce Secretary Gardner. So it's my pleasure to introduce Ms. Jones. In her nearly 20 years in office, Speaker Jones has distinguished herself as an advocate for changing lives and increasing economic opportunity through improved public education and government that responds to the people. She was elected by her peers to serve as the highest elected woman in the Georgia General Assembly in 2010 after serving as Majority Whip. She has authored various bills involving local control, transparency, and accountability. She has also done much to reform Georgia's K-12 education. Speaker Jones lives in Milton, Georgia, with her husband. She is a graduate of the University of Georgia and has an MBA from Georgia State. She's a businesswoman and a mother of 4. I thank her for appearing today. Senator Cotton.
Thank you, Senator Grassley. I am pleased to introduce New Hampshire Secretary of State Bill Gardner, the longest-serving Secretary of State in the country. Secretary Gardner was first elected to serve the people of New Hampshire in 1976, just 1 year before I was born, and Senator Grassley doesn't even want to know how many years before Senator Ossoff was born. He's been serving for that long because he has been serving the people of New Hampshire so well. I would point out that Secretary Gardner is a Democrat, and of course I'm a Republican. I'm sure there are probably some things we don't agree on, but I invited Secretary Gardner to appear because this is not a partisan issue, or rather it shouldn't be. Free and fair elections administered by our 50 state governments are an American issue. That's what our founders intended, and that's why there is bipartisan opposition to these bills that would federalize our state-based system. Secretary Gardner is well positioned to talk about these problems and how this bill would wreak havoc on our elections, but more fundamentally, he can talk about the real problem, the fact that this legislation is a complete takeover of our federal election system. I want to thank Secretary Gardner for being willing to testify. I would suggest to all of those watching that the longest-serving Secretary of State in America and a Democrat has a lot to say that we should probably listen to before we make radical changes to our state-based election system.
Thank you, Senator Cotton. The procedure will follow today. We will swear in the witnesses, and each witness will then have 5 minutes to provide opening statements. There'll be one round of questions, and each senator will have 5 minutes, and I ask them to please try to stay within their allotted times. I would like to ask all the witnesses, and they are in remote status, to please stand in place to be sworn in. Raise your right hand. Do you affirm that the testimony you're about to give before the committee will be the truth, the whole truth, and nothing but the truth, so help you God? I'm going to assume that all witnesses answered in the affirmative. Thank you all. Professor Anderson, please proceed with your opening statement.
Thank you for this opportunity to speak with you about the history of voting rights. I will focus on three key themes that echo powerfully in today's electoral landscape. One, the target of disfranchisement. Two, the use of race-neutral language to evade the 15th Amendment. And three, the cloaking of disfranchisement under the banner of election integrity. In 1890, during the rise of Jim Crow, legislator James Big Chief Vardaman bragged that the sole reason the Mississippi legislature revised the state's constitution was to eliminate the Negro from politics. Similarly, Virginia Representative Carter Glass, like so many others, rushed to champion a bill in the legislature that would inevitably cut from the existing electorate 4/5 of the Negro voters in the state. I call it bureaucratic violence because it is designed to attack and undermine African Americans' voting rights and other citizenship rights, while providing an aura of legitimacy that physical violence simply cannot bring. What Vardaman and Glass were advocating was an omnibus disfranchisement program, the Mississippi Plan, which was modified throughout the South and included the poll tax, the literacy test, the grandfather clause, and other barriers to the ballot box. Not surprisingly, Black electoral participation dropped precipitously. In 1880, for example, Black voter turnout was 81% in North Carolina. By 1912, a few years after the state amended its constitution to include the poll tax, the literacy test, and the grandfather clause, Black voter turnout had dropped to just 1%. The states were able to destroy Black voter participation by violating the spirit and the intent of the 15th Amendment while adhering to the letter of the Constitution. They did so by deploying race-neutral language that used the legacies of slavery as a proxy for race. The poll tax, for example, required all voters to pay a fee to cast a ballot. What the poll tax actually did, though, was to prey on the endemic poverty created by centuries of unpaid labor, followed by the post-Civil War Black codes and then sharecropping. The tax seemed innocuous on its surface, but because of the poverty, it amounted to Black farm laborers paying in 1900 the equivalent of $239 in 2020 to vote. Similarly, the literacy test, which required a voter to read a section of the Constitution, exploited the consequences of denying education to the enslaved for hundreds of years, and then, after the Civil War, grossly underfunding Black schools. The race-neutral ploy worked. The U.S. Supreme Court ruled in the 1898 Williams decision that the poll tax and the literacy test did not violate the 15th Amendment because they applied to everyone who wanted to vote. That decision, of course, ignored that not everyone had to deal with the legacies of having their ancestors enslaved for centuries. The result of the court's blessing of a Jim Crow electorate was that by 1940, only 3% of age-eligible African Americans in the South were registered to vote. These states justified erasing millions of American citizens from the ballot box by claiming they were fighting election fraud and protecting democracy. They knew that wasn't the case. The lie of massive rampant voter fraud is serving the same function today as it did during the rise of Jim Crow. It stokes fear in a segment of the population that democracy is in peril and thus provides cover for laws that target Black voters with race-neutral language. In the 21st century, as Indiana implemented the first voter ID law in the nation, Secretary of State Todd Rokita recalled that back in 2001 and 2002, election integrity was a huge issue. There was a fear of votes being stolen, even, he added, if that fear didn't pan out to be true. The fear was still there. In 2021, as Georgia passed SB 202, State Representative Alan Powell admitted that widespread voter fraud wasn't found. It's just in a lot of people's minds that there was. That fictional Loch Ness monster has led Republican legislators in 47 states to propose 361 voter restriction bills to address concerns about supposed voter fraud. If left unchecked, this onslaught of bureaucratic violence will make the Mississippi Plan look tame by comparison. Thank you.
Thank you, Dr. Anderson. Secretary of State Bill Gardner is next.
Thank you, Mr. Chairman, Ranking Member, members of the committee. I appreciate the opportunity to speak to you today about a critically important issue that impacts all of us, the integrity of our elections, a foundation of our free society. While I certainly support efforts of individual states to improve their own elections, the states have long been testing grounds for innovation in enhancing and protecting the most fundamental right of the citizens in this country. That's our right to vote. With that said, I am deeply troubled and concerned about the direction some in Congress would take the states in terms of the conduct of elections. An unjustified federal intrusion into the election process of the individual states will damage voter confidence, diminish the importance of Election Day itself, and ultimately result in lower voter turnout. We only need to look at the history of the National Voter Registration Act of 1993, that was commonly called the Motor Voter Law, to see that federal involvement in the election process does not render the promised results. When the NVRA was enacted by Congress, it was believed that many more United States citizens would be able to vote and thus vote. Millions of dollars were spent by the states to comply with that act. It completely changed the voter registration process in the states. In contrast, New Hampshire maintained an exemption to the NVRA due to having Election Day registration at the polling place, and as a result, saw its voter turnout of voting age population surge to the top tier of voter turnout among the states, and has consistently maintained its position in the top 3 states for the past 4 presidential elections. Since the year 2000, New Hampshire has been double-digit percentage points higher than the national average, again using voting age population. The attached voter turnout charts will illustrate these trends, and be very important to take a close look at those charts. In a one-size-fits-all federal approach, legislation known as For the People Act would trample New Hampshire's state constitution, which requires all votes to be received, counted, and the results publicly announced on the day of the election, and permits absentee ballots to be used only by voters who will be absent on Election Day or who have a disability preventing the voter from attending the polling place. The election process in New Hampshire is a relatively simple one. The massive federal legislation contemplated by Congress will overcomplicate our election system at tremendous financial costs. It would negate traditions and procedures that have served New Hampshire voters well, some for over 200 years. I believe the charts that I have provided, based on facts, are self-explanatory, and why I believe this legislation, H.R. 1, will hurt, or S1, will hurt voter participation in the states, and especially in my state of New Hampshire.
Thank you, Mr. Gardner. Cheryl and I is the next witness.
Good morning, Chairman Durbin, Ranking Member Grassley, and members of the committee. My name is Cheryl Eiffel, and I'm the President and Director Counsel of the NAACP Legal Defense and Educational Fund, or LDF. Thank you for the opportunity to testify before you this morning. Since its founding in 1940, LDF has been a leader in the struggle to secure, protect, and advance voting rights for Black voters. We represented Martin Luther King Jr. and the marchers in Selma, Alabama in 1965. We've litigated seminal cases interpreting the scope of the Voting Rights Act over decades, and we continue to litigate on behalf of and work with communities in the South to strengthen and protect the ability of Black citizens to participate in the political process free from discrimination. Beyond litigation, we monitor primary and general elections every year through our nonpartisan Prepared to Vote and Voting Rights Defender initiatives, and we're a founding member of the nonpartisan Civil Rights Election Protection Hotline, which is now administered by the Lawyers Committee for Civil Rights Under Law. Last year, we partnered with LeBron James and the More Than a Vote initiative to recruit young poll workers for the 2020 election to ensure that polling places could remain open in Black communities despite the COVID-19 pandemic, and over 40,000 new poll workers were recruited as a part of that effort. Our experience last year, outlined in detail in my submitted written testimony, makes clear that contrary to numerous news reports, the 2020 election did not go smoothly. Instead, voters overcame a litany of barriers and obstacles with determination and resilience to produce the highest turnout ever recorded in a presidential election. And voters did so during a nationwide pandemic. Throughout the spring and summer of 2020, LDF was involved in numerous lawsuits and other efforts challenging the lack of safe and accessible voting options for Black and medically vulnerable voters during the COVID-19 pandemic in Texas, Louisiana, Alabama, and South Carolina. Our lawsuits resulted in changes in mail-in voting requirements, identification policies, and curbside voting access, significantly increasing voter protections and accessibility. Nevertheless, voters stood for hours on long lines to cast a ballot during the primary and general elections, up to 9 hours in some instances. Their determination was extraordinary. One elderly African-American woman who fainted while waiting hours online to vote in the general election in Alabama refused to get into an ambulance, insisting that she would stay and cast her ballot. Polling place closures and consolidations created confusion for voters. Robocalls targeting Black and Latino voters in Flint, Michigan, and Detroit encouraged voters to vote on Wednesday rather than the Tuesday, November 3rd election. The Civil Rights Election Protection Hotline received over 30,000 calls from voters facing obstacles to voting in the general election. And in one of the most disturbing features of the 2020 election, voter intimidation at levels not seen for decades became an alarming feature. For example, during early voting, numerous Floridians received emails threatening that the Proud Boys, an extremist far-right group, would come after voters who did not cast their ballots for the Republican presidential candidate. And the efforts at voter suppression continued even after Election Day, stoked and encouraged by the former president. People across the country in Michigan, Arizona, Pennsylvania, and more participated in a campaign to disrupt the counting and certification of ballots cast in those states. The violent attack on the Capitol on January 6 was the result of concerted efforts to undermine faith in the election and to overturn its results. And since January 7th, state lawmakers in dozens of states have unleashed a wave of restrictive voter laws. According to the Brennan Center, as of March 24th, state legislators have introduced 361 bills with restrictive provisions in 47 states. Georgia enacted a law which, among other restrictive provisions, criminalizes the provision of water to voters standing online. Arkansas and Florida are following suit. A bill in South Carolina would effectively prohibit the Souls to the Polls voter participation effort favored by Black churches by outlawing early voting on Sundays. Litigation is the principal tool we've had available to us to challenge discriminatory voter suppression laws and practices since the Supreme Court ended the preclearance provision of the Voting Rights Act in the Shelby County versus Holder case in 2013. But litigation cannot fully meet the challenge we're facing. It is slow and it is expensive. The average length of Section 2 cases is 2 to 5 years, during which thousands, if not millions of voters are effectively disenfranchised. This is not a model that can be sustained in a healthy democracy. We need Congress to act. The framers of the 14th and 15th Amendments gave Congress the explicit power to enforce the guarantee of equal protection and the protection against voting discrimination based on race. For 100 years, after the ratification of those amendments, until the passage of the Voting Rights Act in 1965, Congress abdicated its obligation to use this enforcement power as Black people were systematically disenfranchised by poll taxes, literacy tests, understanding clauses. Now Congress must once again use this power to fulfill the promise of full citizenship guaranteed to Black Americans by the Civil War amendments to our Constitution. My full testimony has been submitted, and it provides greater detail and source material that I hope will aid the committee in its deliberations. Thank you.
Thank you very much, Ms. Eiffel. And now we have President Jan Jones.
Thank you, Chairman Durbin, Ranking Member Grassley, and distinguished members of the Senate Judiciary Committee for inviting me to testify before today's committee hearing. I come before you as a proud Georgian and member of the Georgia General Assembly, where I serve as Speaker Pro Tem of the Georgia House of Representatives. In Georgia, we're making it easier to vote and harder to cheat. We're ensuring voter accessibility, transparency, and integrity. In 2021, we held both primary and general elections utilizing a new statewide election system during the first modern worldwide pandemic and with record turnout. All these together, along with changes in voter preferences and choices, stressed our election system. Our obligation was to initiate a comprehensive review to assure our state citizens have the ability to vote easily, in a timely manner, and with confidence. But strengthening Georgia's elections processes is not new to 2021. In fact, from 2003 to 2020, since Republicans have had control, 59 elections-related bills were signed into law, including at least one bill each of every year. 2019 legislation addressed concerns primarily expressed by Democrats after the 2018 general election, including a process for curing provisional ballots and lengthening the period to 9 years before some inactive voters are removed from the rolls. Senate Bill 202 is a forward-facing approach to elections, implementing measures to increase voter accessibility and fairness. So please allow me to break down some of the key components. For the very first time, election superintendents shall continue processing, counting, and tabulating ballots until such activities are completed on election day to prevent the untimely release of returns. It makes clear that the business of elections is to be run and funded by the government, not tech billionaires and their partisan allies. Again, for the first time, Georgia law now requires 2 Saturdays instead of 1 and 2 optional Sundays of early voting. Senate Bill 202 creates more uniformity of days and hours of early voting in all 159 counties. Now, 134 of Georgia's 159 counties will offer more in-person voting hours than ever before. I would note Georgia's total amount of 17 to 19 days of early voting is more than Delaware, the District of Columbia, New Mexico, Hawaii, Massachusetts, New York, Oregon, and Wisconsin. For the first time, start and end dates for absentee ballot applications will more logically coincide with in-person early voting and practices in other states. This change will increase the likelihood that a voter successfully casts an absentee ballot. 90% of absentee ballot requests in 2020 made greater than 10 days before the election were successfully voted. In contrast, only 50% of requests made fewer than 10 days before the election were successfully voted. This provision increases successful voting. Certainly, though, the legislation does not prohibit poll workers from giving water to people in line, and even voters bringing their own food and water along with them, as has been the long practice. In fact, the bill does the opposite. It prohibits offering anything of value within 150 feet of a polling place, except for water offered by election officials. This is because in 2018 and 2020, activists and candidates appearing on the ballot aggressively for the first time passed out water, food, gift cards, some with logos affixed to them, at polling locations while voters stood in line. It's a practice commonly referred to as line warming, and surely violates the spirit of free elections. The fact is that most states have a prohibition of activities considered to be campaigning or electioneering within a protected space ranging from 30 feet in Virginia to 100 feet in California to 150 feet in Oklahoma. Finally, I would be remiss if I didn't note the entirely selective outrage I have seen over the last few weeks. As Georgia makes our no-excuse absentee voting more secure, states like Connecticut, Delaware, Massachusetts, New Hampshire, and New York, among others, simply don't have any no-excuse absentee voting. The shame is theirs to bear, not Georgia's. We also eliminated subjective signature matching for absentee ballots and ballot applications, as was criticized by Democrats and Republicans in 2020, and replaced it with objective forms of identification. Let me be clear. Georgia did not eliminate no-excuse absentee voting. It's easy to write alarming words and give misleading sound bites that would lead people away from the facts, because the facts simply don't support what many are hearing or seeing about the mainstream sound Georgia elections law, and it's just plain wrong. Members of the committee, I look forward to answering your questions and setting the record straight on how we're making it easier to vote, harder to cheat, and ensuring every legal vote counts. Thank you.
Thank you, Madam Speaker. I'm sorry if I got your title wrong when I introduced you. I think I elevated you to president in that introduction. But thank you very much for your testimony. We now have Stacey Abrams.
Thank you, Chairman Durbin, Ranking Member Grassley, and members of the committee. Today's conversation regarding the John Lewis Voting Rights Advancement Act does occur against the backdrop of a resurgence of Jim Crow-style voter suppression measures sweeping across state legislatures, grounded in the big lie about fraud and insecurity in the 2020 election. As a necessary reminder, post-Reconstruction laws known as Jim Crow that targeted Black voters never explicitly excluded eligible citizens by race. Then, as now, the laws surgically aimed at behaviors to limit access. With hundreds of bills pending, a significant number of the worst attacks on the right to vote are made possible by the Supreme Court's gutting of the Voting Rights Act of 1965 and the 2013 Shelby County v. Holder decision. That decision authorized states and localities with a history of voting discrimination to again impose limits, restrictions, and barriers to participation. The dramatic proliferation of state-level anti-voting laws across the country in 2021 demonstrates the urgent need for Congress to bring the VRA's pre-clearance formula into the modern era, to reinstate federal oversight over discriminatory voting practices, and to strengthen and protect voting rights wherever suppression occurs. Throughout its history, Georgia has been among the worst actors, including malicious prosecution of lawful absentee ballot users in 2010 and intimidation of Black voters by deputy sheriffs in 2015. Under pre-clearance, the Department of Justice objected to 170 discriminatory voting changes in Georgia at the state and local level. After Shelby removed pre-clearance, analysis showed that Black voters were 20% more likely than white voters to not vote due to poll closures, including an estimated 54,000 to 85,000 voters being unable to cast ballots in 2018 alone after 214 such poll closures. Had the VRA been in effect, these changes would have been examined by a federal court or the DOJ to determine whether they were discriminatory before being put into effect. Georgia voters are now anticipating the deleterious effects on elections created by Senate Bill 202, which relies on misinformation, falsehoods, and flawed analysis to restrict access for voters, primarily targeting communities of color. With dozens of attacks on voting rights embedded in the law, I will highlight only a few. Voters of color in Georgia were more likely than white voters to vote by mail for the first time in the last two election cycles. Suddenly, SB 202 shortens the time period to request to return an absentee ballot application and imposes new restrictive ID requirements that will have an amplified effect on disabled voters, older voters, voters of color, and Black Georgians in particular. Voters of color in Georgia are more likely than white voters to stand in long lines, including the 8-hour debacle that occurred in June 2020. SB 202 criminalizes a volunteer handing a bottle of water or food to voters or their children while in line. Across the country, These state laws target voters of color by restricting access to the ballot for Black, Latino, Asian American and Pacific Islander, and Native American communities. In Texas, Arizona, and Michigan, each are considering laws to restrict voting rights by people of color. When the fundamental right to vote is left to the political ambitions and prejudices of state actors, one who rely on suppression to maintain power, federal intercession stands as the appropriate remedy. Simply put, the John Lewis Voting Rights Advancement Act is essential to the protection of democracy. Protecting voting rights has been a bipartisan endeavor since the enactment of the Voting Rights Act of 1965 and through every subsequent reauthorization. While each of us may likely have a declared party loyalty, our first obligation is to the fundamental standards of democracy, which must be aggressively nonpartisan. Actions taken to restrict access, thwart participation, or discourage engagement are antithetical to our national creed and should be condemned by every patriot. Instead, we must advocate for voting rights, not to ensure the success of a single party or ideology, but to guarantee a vigorous and fair debate amongst Americans of goodwill. It is my profound hope that we will honor the legacy of my late friend, Congressman John Lewis, and the lives of those lost in the fight for a more perfect union by enacting critical legislation into law. I thank you for the opportunity to take part in this important discussion, and I urge you to continue to strengthen our democracy.
Thank you, Ms. Abrams. Let me concede at the outset that Jim Crow at its worst was more violent than the situation we face today. I don't want to recount all of the horrors of that bigotry and racism that occurred in that era. But I think the bottom line question which we are addressing in this hearing is whether there is a design or an intent in legislation that is being considered and passed in many states, including the state of Georgia, to limit or restrict the right to vote of minority populations with the intent of having influence on the outcome of the election. I think that goes without saying. Clearly, there's a difference in the witnesses who appear before the committee. But I'd like to ask Stacey Abrams, for example. The Speaker Pro Tem, Ms. Jones, said earlier that the new Georgia law made it easier to vote in the state. You've recounted a few instances, but can you think of elements in the law that was signed by Governor Kemp which do the opposite?
Well, first is this falsity that's been proposed that this is an expansion of rights. Let's be clear. In the state of Georgia, 60% of Georgians live in counties that already had, for example, 2 Saturdays of early voting. What has changed is that now additional counties will join the ranks, and that is a good thing. But at the same time that those counties will join those ranks, they have reduced mandatory dates. They have eliminated weeks of early voting during federal runoffs. And let's be very clear that federal runoffs in Georgia were predicated on a racist premise of eliminating access to the right to vote for African Americans. And they eliminate access to a mandatory weekend voting day. Another example is the falsity that this expands hours for voting. Yes, it codifies that you can vote between 9 to 5 as business hours. But for 78% of Georgians, prior to this bill, the hours for voting during early voting was 7 a.m. to 7 p.m. So this actually eliminates hours of voting and mandates only a shortened period of time. That was the misunderstanding that I think is still misunderstood by the Washington Post, because early voting hours that exceed that are now optional and not mandatory. We have 78% of Georgians who had experienced longer voting hours and now will see shortened hours. In addition, there is a narrative that says that the use of a Social Security number is allowed for returning your absentee ballot if you do not have access to the ID. Well, let's be clear. You cannot apply for an absentee ballot with your Social Security number. You must have some forms of identification that are unavailable to currently 200,000 Georgians. Those are just a few of the issues. And I will certainly address the criminalization of the handing of water. We have to be clear that in the state of Georgia, 8-hour lines for communities of color has become not an unusual circumstance. Usually we've seen between 4 and 8-hour lines. People do not often come prepared to stand in line for the whole of a business day. They certainly don't often bring their food with them. And this ignores the fact that the overworked poll workers who are inside those buildings do not have the time to come out and hand out refreshments since they are busy processing so many voters who have been underserved. And so I would use those as a few examples of why this bill is deleterious in its effect and malicious in its intent.
Ms. Jones, I'd like to ask you to respond to this question. There was an allegation made by the former President of the United States relating to the voting in the state of Georgia. He went so far at one point in the recorded conversation to say that 5,000 dead people had voted. Mr. Raffensperger replied that there were only 2 that they could find, and that was 2 too many. But I would like to ask you if you would comment on the 2020 election. Do you believe there was voter fraud in Georgia, as President Trump alleged?
You know, I'm here to discuss what's in Senate Bill 202, not relitigate the 2018 election in which my former colleague Stacey Abrams never conceded, nor am I here to relitigate the 2020. What I can say is that the bill does increase accessibility. 47 counties had no 2 Saturdays of voting and will be required to now under this bill. Additionally, not one single Georgian will have reduced hours of voting and early voting because it allows up to 7 a.m. to 7 p.m. But what it does do is mandate from 9 in the morning to 5 p.m. And we had 134 counties with less or fewer voting hours for early voting.
Ms. Jones,
the bill absolutely does increase the amount.
If I could follow through on that, the reason for my question is this. I'm trying to understand the logic behind new voting laws, which would give less time to request absentee ballots, strict new ID requirements for absentee ballots, illegal for election officials to mail out absentee ballot applications and the like. In light of the 2020 election, I believe Mr. Raffensperger spoke the truth, and there certainly was no evidence to suggest otherwise when he suggested that the election in 2020 following the old law was absent any major voting fraud and should not be questioned in terms of results. So if the premise was 2020 was sound, why the changes that restricted certain practices that created opportunities for people to vote in Georgia?
Thank you, Chairman Durbin, for the question. Since 2003, 59 elections bills have been passed by the Georgia General Assembly, at least one each of every year. After the 2018 elections, we had an elections bill that addressed some of the concerns expressed by Democrats. In this bill, after a worldwide pandemic, record turnout, a new election system, once again, we're coming back to address concerns expressed by both Democrats and Republicans. The bill absolutely will reduce the long lines, and it will make clear that it makes clear there has to be proper notice so that voters can know if a precinct is changed. It has to require notice at the old precinct location with a 4-foot by 4-foot sign, also at the new location. There are many provisions in it, but let me just mention specifically with regard to your question about shortening absentee days to request an absentee ballot. As recommended by the Association of County Commissioners, which is a bipartisan group, and the U.S. Postal Service, our timing to request an absentee ballot allowed someone to request one the Friday before the regular election, which almost certainly meant they would have an unsuccessful vote. And so this moves it back to 10 days, which is more expansive, I will admit, 11 days than what the U.S. Postal Service recommended, which was 14 days. But it, I do believe, will result in more successful absentee ballots cast, regardless of whether one lives anywhere in the state and whether they're a Democrat or a Republican.
I'd just say in conclusion that giving Georgia voters under the new law less time to request absentee ballots and shutting down the number of drop boxes from 94 to 23 cannot make it easier to vote or create more opportunity. I think just the opposite is the case. Senator Grassley?
No, I don't know what you're talking about. Speaker Jones, Did you look at any other states for guidance or inspiration in the provisions of SB 202?
Yes, sir, we most certainly did. We wanted to make sure that although our voting system is more expansive than many in the country, particularly in the Northeast, we wanted to make sure that any changes we made were mainstream, common sense, and made it easier, more fair, more transparent, and secure for a voter, regardless of their geography or whichever party they tended to vote for. And I do believe this bill does that. We, unlike, frankly, most states in the union, we do have a voter ID, which is common sense regulation and required to pick up a child from daycare, board a flight to go visit grandmother. It's to cash a check. And I think the bigger issue for the 3% who do not currently have a either driver's license or a free, and I emphasize free voter ID, I'm most concerned about their ability to participate in the 21st modern century and society as a whole. And that's perhaps where we should give our efforts to, is not undermine the security of elections for absentee ballots, but rather help the few that don't have one to obtain one. Thank you, sir.
Also to you, Speaker Jones, can you tell me what SB 202 does to reduce lines at vote? And if it's got 10 examples that you can give me just one or two.
Yes, sir. Thank you. Because particularly in the June primary, when we had a brand new election system, elections officials, poll workers were learning how to utilize the machines. We did have some long lines in some areas of the state. They were primarily in counties that are Democrat run. But regardless of that, what we did was we have required that at any single point in time in the next general election, if there is a line of 1 hour or longer, at the next following subsequent general election, the election superintendent for that county must either split the precinct, add poll workers, add machines, or all of the three.
I'd like to ask Secretary Gardner, Iowa and New Hampshire brag about first in the nation, one for caucus, one for primary. In fact, HR 1 or its state equivalent, S1, is passed. If so, what effect do you think that would have on the ability of our states to preserve their first in the nation status?
Senator, S1 would not specifically have an effect. However, I've made the statement that it could put the New Hampshire primary in a perilous position, and I stand by that statement.
Okay, let me ask you. Let me ask you one other question. Your state has voting laws that are seen as restrictive, yet as you told us in your opening statement, it's consistent that consistently has some of the highest turnout elections in the country. Would you agree with me that voters tend to turn out more for elections when they have more confidence that their vote will be counted appropriately? And what effect has your voter ID provision had on turnout?
Absolutely. The trust and confidence voters have in the process is a huge boost to turnout. And New Hampshire had a voter ID law for the first in the 2012 presidential election. And so 2020, 6 months ago, that was the third presidential election that we had voter ID. We had, in 2012, the highest turnout since 1960 in New Hampshire, over 14% higher than the country as a whole, and higher than we had had in over a half a century among our own presidential elections. in 2012. In 2016, we even went higher than that, 14.5% higher than the country as a whole, with the second presidential election using voter ID. And 2020, it was the same. When voter ID was going through the legislature, there were people saying that 10% of the population was not going to be able to vote. This would hurt certain groups more than it would hurt other groups. And there were polls that nonprofits like Pew published and came and testified in our hearings saying that it could be 11% decline. And in our state, it was just the absolute opposite. As I said, 3 presidential elections in a row, averaging, you have to go back a half a century. So those are the facts on that issue in New Hampshire.
Thank you, Mr. Gardner. Senator Whitehouse, remote.
As you know, I am inclined to ask why about things, and I can't help but wonder why, after the Trump administration top election security official and Georgia's own election officials vouched for the integrity of the last elections, did seemingly every Republican-controlled legislative body in the country pivot, as if on command, to file and move voter suppression bills. 361 of them by one count. When you see group behavior, it's often interesting to look for the motivation. Well, you have the big lie that the election was stolen, which allows for skepticism to be brought against elections, even if it's not founded in fact. And at the same time, you have unpopular policies demanded by a Republican donor elite that has every interest in building an electorate that will give the donor elite its policies rather than giving up on their policies in order to attract voters. As our friend Reverend Warnock says, limiting voters serves this, particularly when limiting voters is to make sure that some people aren't voting. And of course, dark money is that donor elite's weapon of choice. And we see that conservative dark money groups have already announced $39 million in spending campaigns to restrict voting rights at the state level and block passage of the For the People Act. And that number is likely going up because these very same groups spent over $100 million in dark money during just the 2018 election cycle. At the state level, we see 2 particular groups very prominent. One, the State Policy Network, and 2, the American Legislative Exchange Council, the so-called ALEC. ALEC is toxic enough that Exxon severed its ties to ALEC. When ExxonMobil thinks it needs to clean up its act by severing from you, that's a pretty strong signal. So ALEC has singled out Representative Jones for praise, calling her an ALEC legislator. ALEC is funded by Koch Industries. It has received millions of dollars from right-wing foundations like the Charles G. Koch Charitable Foundation, the Searle Freedom Trust, the Bradley Foundation, and also through the Identity Laundering Donors Trust and Donors Capital Fund. It's working now with the Heritage Foundation on a $24 million campaign to produce model voting legislation for state legislatures like Georgia's to adopt, and even to hire lobbyists in what they call crucial states. ALEC has created a secret working group on election-related matters led by Cleta Mitchell, who many people will remember for her role backing Trump's efforts to flip Georgia's election results. So ALEC has its hands all over this. There's also the Georgia Public Policy Center, which is the local affiliate of the State Policy Network. Representative Jones has said, I want to publicly say how much I appreciate Georgia Public Policy Foundation We rely on Georgia Public Policy Foundation's research and work. They've been an invaluable resource to us. Well, guess what? ALEC is an official associate organization of the State Policy Network with the Georgia Public Policy Center. And the group, the SPN, State Policy Network, has paid for dozens of its think tanks to become ALEC members. So there's a lot of back and forth between the Dark Money ALEC group and the Dark Money State Policy Network. Like ALEC, State Policy Network is largely funded by big corporations and right-wing family foundations, including the Koch brothers, the Waltons, the Bradley Foundation, the Roe Foundation, the Coors family, and of course, the ubiquitous identity launderers, Donors Trust, and Donors Capital Fund. There are lots of other familiar names moving into this space. The Heritage Foundation, the Koch-funded dark money group's political arm, Heritage Action for America, announced plans to spend $24 million on a 2-year effort to shape states' voting laws and to work at the federal level to block the For the People Act. In March, Heritage Action boasted that Heritage Action recently launched an effort to strengthen Georgia's election laws and restore voter confidence in the state, including a $600,000 TV ad buy, digital advertising, and a grassroots advocacy initiative for an initial total investment of $1 million. And that's a quote from them. At the same time, we have the so-called Honest Elections Project, which is Leonard Leo's new outgrowth of his vast dark money network that has pledged tens of millions of dollars into conservative election efforts. Honest Elections Project is an alias group that can use all of the anonymous funds given to its pre-existing judicial education project, which Leo used to steer Bradley Foundation grants into coordinated amicus brief efforts that I've chronicled elsewhere. His Honest Elections Project for Georgia released a string of press releases urging Georgia to investigate its 2020 results and to take up voter suppression legislation, and congratulated the state for enacting SB 202 last month. Last is True the Vote, a group whose main aim has been to recruit poll watchers, whose task of finding suspicious activity is often focused on voters in neighborhoods of color. Like the other groups, its finances are largely opaque, coming through anonymized donations via a Donors Trust, as well as the Bradley Foundation and, of course, the State Policy Network. So there is this complex interlocking network of billionaire right-wing dark money that I think tends to signal why the whole herd would have moved at once based on no actual evidence of fraud or dishonesty in the elections.
Thank you, Senator.
Has my time expired?
I'm afraid it is.
My apologies. My clock doesn't run when I'm remote, and I will yield my non-existent remaining time. Thank you, Chairman.
Senator Graham.
Thank you. To my dear friend, Sheldon, I appreciate your consistency. So what would account for the elephant herd is apparently marching in one way. H.R. 1, I believe, is supported by most every liberal group in the country. Most of my Democratic colleagues support H.R. 1. Why? What motivates you? Redistricting. Under your proposal, you would take redistricting away from state elected officials and give it to some independent commission. What's that got to do with voting? That's about trying to change the ability of red states to be able to draw new lines based on population shift. H.R. 1 has a 6-to-1 match for low dollar donations. What's that got to do with voting? Nothing. It's got to do with political power, trying to have the federal government subsidize campaigns favorable to you. And if 6-to-1 match had been in place in my recent election, South Carolina would have probably had over $1 billion spent. I think the people of South Carolina deserve better than that. I raised 110. My opponent raised 132. If you had a 6-to-1 match, it'd have been about $1 billion. I think that's cruel and probably violates the Geneva Convention. So H.R. 1 is not about righting wrongs. It's about power. It's about trying to grab power, and I can understand why people want to grab it. I don't understand why people on our side would willingly sit on the sidelines and we're not. But we're here today to talk about the voting process. Mr. Gardner, you're sort of a legend in your part of the world. I think rightly so. It's my understanding that you oppose H.R. 1 in the Senate equivalent. Is that correct?
Yes.
In 30 seconds or less, why?
Well, first of all, we don't have any early voting in New Hampshire. And for all the studies that show that early voting actually helps turnout, I can show you plenty of academic studies that show the opposite. That just because you make voting easier does not raise the turnout automatically. And we have election day that is a day for everything in New Hampshire. It goes all the way back to the beginning. Our Constitution predated the federal Constitution, and it ends that day. It's our tradition because every polling place, the chief election officer has to, that evening of the election, read publicly the votes cast for every candidate on the ballot, and that is the end of it. And our early voting, that what is called early voting across the country, is just not allowed under our Constitution.
So you believe that it would be a power grab when it came to New Hampshire voting? Is that fair to say? By the federal government?
Yes. And the same thing with no-fault absentee.
Okay.
We didn't even know, it's the same thing.
Thank you very much. The Carter-Baker Commission looked at voter fraud in voting in 2008. They found that there's no evidence of extensive fraud in U.S. elections or multiple voting, but both occur, and it could affect the outcome of close elections and many other findings. The absentee ballots remain the largest source of potential voter fraud. That's what the Carter-Baker Commission said, not me. The Carter-Baker report said, recommend to reduce fraud, recommend prohibiting third-party organization candidates and political party activists from handling absentee ballots. I think that's related to ballot harvesting. So my question for Ms. Abrams, do you support voter identification laws?
Yes.
Okay. Do you
There
support...
are 35 states in the United States that have had voter identification laws.
Okay.
In fact, every state requires some form of identification.
Okay.
What I have objected to is restrictive voter identification laws that narrow the set of permissible materials that allow you to prove your identity.
The answer is yes as a concept. Do you support the idea that voting should be limited to American citizens?
Yes.
Do you support that we should have, do you support ballot harvesting? Are you familiar with that term?
I'm familiar with the term of art that's been propagated to describe a variety of efforts. But for example, on Native American reservations where they are precluded from access due to underfunding to reach in a timely fashion locations for voting, I do believe that it's appropriate for tribal elders to collect the ballots and retrieve them and use a single source of delivery to provide those ballots and thus provide Native Americans with the opportunity to participate in elections.
Do you support it beyond Native American voting?
As I've said, I believe that it depends on the situation and that the term of art that is being used describes a variety of behaviors, and each of those behaviors should be examined for utility and for veracity. And to the extent that they help voters participate in elections in a lawful manner, they should be permitted.
Okay. Do you believe the Republican majority in Georgia, House, Senate, when they are making the changes to your state voting laws, do you think they're motivated by trying to suppress the African American vote?
I have seen it happen sometimes that they are. I've seen other bills that have been truly bipartisan in nature that have looked at and fully examined.
But you believe that's the motivation behind? Do you believe that's the motivation behind these laws?
I believe the motivation behind certain provisions in SB 202 are a direct result to the increased participation of communities of color in the 2020 and 2021 elections. I have participated for 11 years As Speaker Pro Tem Jones pointed out, we served together, and almost every year there was a voting law. And when those voting laws were neutral, not only on their face,
Well,
but in
I'm
their,
out of time. Do you
I would
think,
support
do you
it.
think the Speaker of the House, Speaker Pro Tem, the lady, Jan Jones, is motivated by trying to limit the African-American voters in Georgia? Do you think
I
that's...
believe there is racial animus that generated those bills. I would not assume that that racial animus is shared by every person, but if the result is that racial animus exists and it eliminates access to the right to vote, then regardless of a certain person's heart, if the effect is deleterious to the ability of people of color to participate in elections, then that is problematic and that is wrong and it should be rejected by all.
Senator Klobuchar.
Thank you very much, Mr. Chair. Thank you to our witnesses. I'm just looking at the facts, and I think that we need to get these facts straight. In the 2020 election, more than 160 million Americans voted, more than ever before. And in fact, the Trump administration's Homeland Security official charged with protecting elections deemed the election the most secure election in American history. Is that correct, Ms. Abrams?
That's correct.
And former Attorney General Barr stated that there was no evidence of widespread voter fraud that could have changed the outcome of the 2020 election. Is that right?
That is also correct.
So my problem is this. Why do you think 361 bills have been introduced in 47 states that would restrict access to the polls when, in fact, the way things were running was working for the people of this country? They were voting by mail like never before. They were exercising their way to vote, their right to vote, and they did it safely. Why did this happen?
With all due respect to Secretary of State Gardner, I would actually refer us back to Senator Sheldon Whitehouse's commentary, and that is this. We saw an increased participation from communities that are considered unfortunate or that are not favorable to Republican victories. No one is entitled to win. I am a person who is a living example. There is no entitlement to victory, but we are all entitled to participation. And what these laws have done in stunning and uniform fashion is reduce entitlement to participation. They've done so by targeting behaviors that are specifically attributable to communities that voted in opposition of Republican values. Now, that is not to say that every person of color intends to vote Democratic. It's not to say that every young person votes Democratic. But when the overwhelming majority in those communities exercise their right to vote in this last election, we have seen a raft of laws that have been targeted at their behaviors. And when laws are targeted at the behaviors of communities of color, that is not only reminiscent of the Mississippi Plan and the Jim Crow laws, as Dr. Anderson has so clearly played out, those are intentionally a resurgence of voter suppression similar to Jim Crow, which is why we use that language, because we cannot leave our history behind.
Thank you. And as Reverend Warnock said earlier, maybe it just boils down to some words, and that is that some people don't want some people to vote. Ms. Eiffel, can you tell me about how rare voter fraud is? I think there was a recent editorial in a major newspaper talking about since 2000, Oregon has sent out more than 100 million mail-in ballots and documented only about a dozen cases of fraud, rounded to the 7th decimal point. That's 0.0000001% of all ballots. Ms. Eiffel.
That is correct, Senator Klobuchar. You have a better chance of being struck by lightning than finding widespread voter fraud. And in fact, President Carter spoke out about the report that was referenced earlier. He believes that the report was being distorted to support the provisions of SB 202. In fact, what the report called for was a deeper study of vote by mail. They were basing their study on 2005 to 2008. And the report specifically noted that we have two states, Oregon and Washington state, that do all voting by mail. And there is no significant voter fraud in those two states. And so voter ID, for absentee voting, that's actually quite unusual. There are only 3, I guess now with Georgia, 4 states that require photo ID for absentee voting. And that's what we're talking about with SB 202. It's actually a rare and unusual thing.
Thank you. And we are going to be marking up the SF, Senate File 1, in the Rules Committee, and so I'm pretty familiar with this bill. And could you explain, Ms. Eiffel, why, yes, it has some very important standards for voting, given what we're seeing, the assault on voting across the country, but why, given that we have not had any federal campaign legislation passed since McCain-Feingold, which was basically dismantled by the courts, it is time to also focus on all of the dark money flooding into our politics, as well as ethics rules that are necessary for all of us. And that used to be a bipartisan issue.
Well, I think, Senator Klobuchar, it's important to see this all of a piece. This is about access to the political process. This is about ordinary people having access to the political process. We think of the right to vote as sacred, the casting of the ballot, the counting of that ballot. But if there are forces that neutralize the ability of that ballot to have meaning, then Congress needs to examine that also, so that citizens can feel that they truly have a role in our democracy and have their voice heard. It can't be a sham. It can't be a shell. When activists marched and risked their lives for the right to vote during the civil rights movement, they weren't just looking at the ceremonial act of casting a ballot. They truly believed that being able to participate equally in the political process would allow them to meaningfully change the condition of their lives and communities. And so everything that bears on the ability to give that vote meaning, it seems to me, is relevant and important for this committee to consider.
Thank you. And with your indulgence, just one very fast question with a fast answer, Ms. Abrams. One of the things as I prepare for this hearing that I'm chairing next month, one of the arguments made is that, oh, it'll be so hard for states to enact these. However, we already have 43 states with early voting, 21 states with same-day registration, 19 states with automatic voter registration, 45 states that allowed all voters to cast a ballot by mail last year. In 2018, Michigan approved many changes to its election procedures that went into effect before the November 2020 election. Would you agree that states like Georgia and others have been able to implement these changes in a correct way without a problem?
Absolutely.
Thank you.
Senator Cornyn.
My first question is for Ms. Abrams. Ms. Abrams, is the Georgia election law that Speaker Jones talked about, is it a racist piece of legislation?
I think there are components of it that are indeed racist because they use racial animus as a means of targeting the behaviors of certain voters to eliminate their limit their participation in elections.
So you believe that the Georgia legislature made deliberate attempts to suppress the minority vote?
Yes.
Georgia has a no excuse absentee voting provision in that law. As Ms. Jones, I think, has said, certainly in her written statement, Connecticut, Delaware, Massachusetts, New Hampshire, and New York do not have any no excuse absentee voting. Are the voting laws in Connecticut, Delaware, Massachusetts, New Hampshire, and New York racist?
I would say that they are behind the 8 ball and they need to be improved, and that's why I support the For the People Act voting rights provisions that would expand access to no excuses absentee voting. But as we explained earlier, it is how these behaviors are targeted. The state of Georgia targeted communities that used these resources for the first time to their benefit, and thus, after 15 years of Republican-dominated use of absentee balloting, it suddenly changed its mind about the utility, the processing, the timeliness.
So you do think, excuse me, we only have 5 minutes to ask questions, and so if you would respond to my question. So just to be clear, you think Connecticut, Delaware, Massachusetts, New Hampshire, and New York that have more restrictive, no excuse absentee voting, you believe those election laws are racist?
Senator, I'm responding to your question. Your question is...
No, Ms. Adams, you're
No,
filibustering. Could you answer yes or
I'm
no?
not. Sir, I'm not filibustering. I'm stating very specifically. I believe that restrictive voting laws should be addressed by the For the People Act. I believe that the Georgia decision...
So just to be clear, whether they're racist or not, you think they need to be changed because you disagree with them, right?
No, that is not what I've said. Okay. I have said that those laws that were changed in 2021 in response to an increased use by people of color laws that were put in place by Republicans 15 years ago, and they were perfectly satisfied with the utility of those laws until they were used successfully by people of color. The intent matters,
and you
the
think
intent
that
behind these laws matter in the state of Georgia.
You think voter ID requirements are racist?
No, sir. I've always said that. In fact, I wrote a book about the
Doesn't
fact that
that restrict? Doesn't that restrict voting? The requirement of a voter ID?
I support voter identification. What I object to is restrictive forms of voter identification that limit who is permitted to use their identifications and that create a narrower and narrower list.
And Georgia gives you can use a free ID or a utility bill or something like that. So you don't believe that the Georgia law restricts voting because of the voter identification requirement?
That is not what I've said, sir. What I said is that the absentee ballot requirement that now adds voter ID in an exceptionally rare usage, because it will now push almost 200,000 voters who do not have access or do not currently have those IDs out of the process.
So
and
voter ID,
people of color.
Sometimes it's racist, sometimes it's not racist.
The intent always matters, sir, and that is the point of this conversation. That is the point of the Jim Crow narrative, that Jim Crow did not simply look at the activities, it looked at the intent, it looked at the behaviors, and it targeted behaviors that were disproportionately used by people of color.
Do you know that Gallup says that 69% of black voters support voter ID and 75% of voters overall?
Sir, I'm among those who support voter ID. I've never objected to voter ID. I object to narrowly tailoring and narrowing the permissive ability.
So you agree with voter ID in some circumstances and not in others?
That's not what I've said, sir.
No, you said it based on intent. So voter ID without malintent is okay.
No, sir, that's not what I said.
Well,
Senator, I'm happy to respond to your questions.
Ms.
But
Jones,
if you're going to
I have a question for you in my remaining time. Ms. Jones, Connecticut, Delaware, Massachusetts, New Hampshire, New York don't have any no excuse absentee voting. Georgia decided to permit it. Why the differences between Georgia and these other states?
Thank you, Senator Corbin. Georgia has a long history, particularly since Republicans have been in charge since 2003, of expanding access to voting. Senate Bill 202 does no differently, and the voter ID requirements that are being put in place for absentee voting are no different than the voter ID requirements for in-person or early voting. They are precisely the same.
Mr. Chairman, can I ask one last question of Mr. Gardner? Mr. Gardner, I think you said that there is no early voting in New Hampshire, but you don't believe that impacts turnout. Could you explain that? That seems a little counterintuitive.
Yeah, it certainly is counterintuitive, but it's factual. If you take a look at the charts that I've submitted to the committee, the two important things: New Hampshire has no early voting. We have election day, and it stems back to our Constitution from a long time ago. And the second one is the no-fault absentee. That's unconstitutional in New Hampshire. But the chart is really important. If you look at the chart that I gave, and I'm going to be this very specific with it. I've been Secretary of State during 12 presidential election years. The first 5 presidential elections, the state of Oregon had a turnout higher than New Hampshire in each of those 5. Starting in 1996, after Oregon decided to go to all mail voting, we've had 7 presidential elections. Oregon has had a turnout lower than New Hampshire in all 7 of those presidential elections. That's fact. So I've lived through these years watching results that take place in certain states. And that's why I'm not projecting onto the country what New Hampshire does, because other states are different than New Hampshire. But what I'm saying is, in my state, I've seen over the years what ways to make it easier to vote actually work and what ways that make it easier to vote do not work. And these charts are factual. It's this all factual information. So for 7 presidential elections in a row, ever since Oregon decided to get rid of election day registration at the polls and go to no fault, everyone is mailed a ballot. There are no polling places. They have multiple days to vote, multiple locations where they can cast their ballot. Now, academics say that's the easiest, it's the effortless, but I know what has happened between the 2 states. Secretary of State of Oregon actually tried to convince me back in the early 90s to join with him because he thought that in 5 years, the whole country would be voting by mail if New Hampshire did it on the East Coast and Oregon did it on the West Coast. So this is factual. And those charts that to the committee, I implore you to take a look at those charts. It ranks every state, all 50 states, starting in 1976, where they ranked. Take your own state, take a look at it. Compare one state to another state. Now, it's based on voting age population.
Thank you, Mr. Gardner. Thank you very much. Senator Coons.
Thank you, Chairman Durbin, and thank you to our witnesses today and to this committee for paying so much attention to the urgent issue of voting and the rights of Americans to vote. It is so profoundly disappointing to me that in 2021, following our last election, we need to have a hearing to address a surge in voter suppression efforts around the country. In a healthy democracy, the side that loses an election then takes time to reflect on why and how and what the issues were that might have moved voters to their side. We instead see in legislatures across the country efforts to suppress the access to the ballot box, the opportunity to vote. Bills like the one that passed in Georgia, I view as an affront to the legacy of John Lewis and others who risked or pass the Voting Rights Advancement Act, now renamed the John Lewis Voting Rights Advancement Act. And I want to ask some questions about that today and about our efforts to try and plug the hole created by the Supreme Court's ill-conceived, I think, decision in Shelby County in 2013. Ms. Eiffel, if I might just start with you. As a matter of common sense, I think we all have a pretty clear idea of why some states are pursuing these laws. But under the Voting Rights Act as it currently exists, can you explain why these laws are so difficult to successfully challenge in court?
Thank you, Senator Coons. As I said at the outset, litigation is one of the tools that we have available, and we, by the way, have challenged SB 202 under the Constitution. We challenged it under the First Amendment, under the 14th Amendment, under the 15th Amendment, and under the Voting Rights Act. But litigation it takes a long time. It is expensive. It can take from 2 to 5 years. I'll give you an example. LDF was part of the team that successfully challenged Texas's voter ID law between 2014 and 2018. But during the pendency of that litigation, there were 500 offices that were elected in Texas, justices of the Texas Supreme Court, attorney generals, district attorneys, lower court judges, county council persons, elections that proceeded despite the fact that we had demonstrated in our litigation that 600,000 Texans were likely disenfranchised by that particular voter ID law. So litigation is a blunt instrument. What preclearance gave us was the opportunity to get out ahead of voting discrimination before it happened, to have a review of the kind that should have happened with SB 202, which is one of the features that hasn't been talked about. The way this law was rushed through, we were there, bills were dropping at 11 p.m., and then hearings were held on them the next day at 7 a.m. As we tried to keep up with this process. This sweeping bill, this omnibus bill, was passed in this fashion that didn't even give a real opportunity for study. Where is the racial impact study on these provisions and how they will affect Black voters in the state? You won't find it because it wasn't done. A preclearance provision would have allowed a neutral authority, a federal authority, to look at every single proposed voting change and to determine the effect on Black voters. And that would then answer Senator Cornyn's question about what was the motivation, what is the effect of the laws. But we didn't do that because we don't have preclearance and because Georgia was hell-bent on pushing this law through as quickly as possible. And so now we're left with litigation.
Well, thank you, Ms. Eiffel. Ms. Abrams, good to see you again. How would having the John Lewis Voting Rights Advancement Act in place operate on other similar laws in the future? And given the point you made earlier about the timing and the intent and the context of voting legislation is critical, how would pre-clearance analysis have impacted the enactment of Senate Bill 202?
Senator Coons, you frame it properly. What pre-clearance does is look not simply at the piece of paper before you in the form of the law, but look at the context, look at the history, and look at the effect. Those have to be taken in totem because Georgia has a different history than, let's say, Texas or New Hampshire. And in each state, one would have to look at what has happened when these things occurred, not in the macro, but in the very micro sense of what happened in the places where these laws are taking effect. For example, in the state of Georgia, the closure of polling places, 214 that closed by 2018, led to between 54,000 and 85,000 voters not being able to cast their ballots because they could not get to their polling place. This is not incidental. This is the difference in elections. We also know that the requirement of providing ID for 200,000 voters who have not been required to physically send in their identification will change how they can participate in our elections. And despite the misnomer of free ID, there's nothing free about identification when you have to pay for the paperwork to comply with the identification.
Ms. Abrams, if I might ask you a quick closing question. One provision in SB 202 surprised me or concerned me. It strips authority over election administration from the Secretary of State and transfers it to the state legislature. Given the context of the 2020 election, how will this transfer of power affect the partisanship of future election administration, and how would you read it, given the recent history in Georgia?
This is a very, very offensive language that not only removes home rule, it actually will put into power people who have nothing to do with communities. And for a body that seems to believe that those who are closest to the people should be making the decisions, giving these, number one, giving state legislatures the authority on their own motion to remove officials, elections officials, is dangerous. If that had been in place in 2020, the outcome of the 2020 election could have been vastly different. And we should be deeply concerned by the aggressive and naked attempt to wrest control away for purely partisan purposes.
Thank you, Ms. Abrams. Thank you for what you and Fair Fight Action are doing. Thank you, Ms. Eiffel, and thank you to everyone who's participating in today's hearing. Thank you, Mr. Chairman.
Senator Lee.
Thank you, Mr. Chairman. I'm disappointed and frankly shocked that the majority party and the chairman would choose such an inflammatory title for this hearing by calling it Jim Crow 2021. The lack of judgment in this instance not only belittles those who endured such dehumanization and indignities through the Jim Crow era, and it also reminds all of us, or certainly should, of what Jim Crow was and how and when it happened and under whose leadership. We have to remember that it was, in fact, Republicans who pushed through the 13th, 14th, and 15th Amendments of the Constitution following the Civil War. 13th Amendment, getting rid of slavery. 14th Amendment, guaranteeing all Americans, and including Black Americans, who had been slaves and those who would not, equal protection under the laws. And including the 15th Amendment, guaranteeing Black Americans the right to vote. These had a significant effect. They were enacted with great opposition coming from the Democratic Party. We got them through. The 15th Amendment was the last of the three to be ratified. It was ratified on March 30th, 1870. 1870 was a big turning point for civil rights in America, for Black Americans. It was in 1870 that we saw the very first member of Congress, a gentleman by the name of Joseph Rainey, who was elected to the House of Representatives in 1870. The same year, the first Black American was elected to the United States Senate. That's Hiram Rhodes Revel, who was elected to the Senate, the U.S. Senate from Mississippi. All in all, during the Reconstruction period, there were 16 Black Americans elected to the Congress. There were over 600 Black Americans elected to state legislatures, and there were hundreds and hundreds more elected to local positions throughout the country. All of them, every last one of them, happened to be Republican. Jim Crow was a response to that. White Americans who didn't want Black Americans coming into power and who resented their votes as Republicans, in fact, didn't want them to have the right to vote at all, notwithstanding the fact that the 15th Amendment had by then been ratified, figured out a way to suppress them. And once President Rutherford Hayes, through the Compromise of 1877, ordered the withdrawal of federal troops from the South, it paved the way for Jim Crow. Jim Crow policies restricted unconstitutionally the right of Black Americans to vote, and it restricted all kinds of other behaviors put in place by Democratic governments in each of those states. It was an unfortunate era, one that lasted for roughly a century, to make sure that Black Americans could not only not vote, but they couldn't be elected. Michael Lancaster is the Georgia State Director of the Frederick Douglass Foundation and the descendant of people who suffered under Jim Crow. In a recent Washington Times article, Mr. Lancaster stated, quote, "Comparing absentee ballot changes and ID requirements to banning Black people from restaurants and drinking fountains is absurd. A civil debate about voting rights is an important conversation to have, but comparing Georgia's election reform to Jim Crow is simply insulting to my Black ancestors who suffered through those dehumanizing segregation laws." There are some others who wrote, quote, "It has become clear that even well-intentioned critics of the Georgia law simply have no idea what the law is. It is clear that they have no idea how favorably Georgia's new law compares with most other states, including President Biden's home state of Delaware. And it's clear that they have no idea that a majority of Black voters across the country support key provisions attacked by critics, including the provision that it's a simple requirement that voters be able to identify themselves upon voting." Speaker Jones, as I understand it, 77% of Americans support voter ID requirements, and specifically 74% of Georgians, including 63% of Black voters in Georgia, all of whom, and all of those numbers indicate support for the new Georgia voter ID requirements. Is that correct?
That's correct, Senator.
And so if a potential absentee voter in Georgia does not have a driver's license, he or she could also show a state-issued voter ID card. Is that also correct?
That is correct, or one of the other forms of federally accepted forms of ID.
And if somebody doesn't have that, then that could be provided free of charge. Is that also right?
That is correct. At any Department of Motor Vehicles office or at any of the 159 elections boards. But please, if I may, Senator, the voter ID requirements are not more restrictive for absentees now than they have been widely accepted and certainly not criticized in the past for Georgia. It's precisely the same requirements to vote in person or to vote by absentee. It actually seems kind of incongruent to make rules for one form of voting but not another. But thank you, Senator.
Mr. Chairman, I see my time's expired, and I suppose I'll be able to submit some additional questions for the record. I would note in closing, Secretary of State Raffensperger was, I'm told, interested in testifying and willing to testify at this hearing. You've invoked his name several times. It's disappointing that the Secretary of State of that state isn't here to be able to testify in response to that. I also want to thank my friend and Utah colleague, Congressman Burgess Owens. This is a man who has been alive, has existed in this country at a time when Jim Crow laws were still in effect. And in some ways, he's been subjected to some of the same insults underlying Jim Crow. He's been lampooned, he's been drawn in caricatures alongside a Klansman in a brazen act of demeaning someone based on his race, demeaning him in a way that ignores the truth, the reality behind Jim Crow laws. This was a system of laws designed to help hold Black Americans back. Hold them back in part because white Democrats in the South didn't want them to vote and didn't like the fact that they were voting as and being elected as Republicans. So let's not compare a voter registration law, one that makes sure that dead people can't vote, to that. We can do better than that, and we should.
Thank you, Senator Lee. For the record, and I will concede, the era of Jim Crow in the South was propagated primarily by Democrats, Southern Democrats and segregationists. The political alignment changed in America starting in the late 1950s and the early 1960s, and Republicans became more dominant in those states for the most part. What we have today is the party of Lincoln, which is refusing to join us in extending the Voting Rights Act. That used to be a bipartisan exercise. Democrats support the extension of the Voting Rights Act and trying to overcome the Shelby County decision and making certain that we can review every state's activities as to whether or not they are fair or not fair. So I would concede the historical point, but I don't think that the senator stuck with the proposition to the present day. At this point, we have Senator Blumenthal. Is he available by remote?
Mr. Chairman, if I could respond to that.
You may, of course.
For a moment. Look, so Republicans never ceased to be the party, never ceased to be the party that believes that the 13th, 14th, and 15th Amendments matter, and that the inherent dignity of the immortal human soul is such that it should never be denigrated by subjecting someone based on their race to a lack of civil rights. So it's not fair, it's not accurate to portray the two parties as having somehow crossed as if in the 1950s. It's just not accurate. And yeah, some Southern Democrats later became Republicans. That's true. That didn't change the Republican Party's alignment on this issue.
My point was the political alignment has changed. That's obvious. And secondly, the Voting Rights Act, which is the nature and subject of this hearing, used to be a 98-0 proposition. Now only Democrats will vote for it since Congressman Sensenbrenner is gone.
Yeah, you're talking about Section 5 of the Voting Rights Act, which subjects some states to pre-clearance. The designation of pre-clearance and concerns of a constitutional nature raised by the Supreme Court of the United States itself is very different than stated opposition to the Voting Rights Act itself and to the many other provisions that have done some good and that still have overwhelmingly, entirely bipartisan support. And I resent that.
Well, I'm sorry you resent it, Senator, but it's a fact that we are dealing with a Voting Rights Act which used to be universal and bipartisan and now is not. The Democrats support it, the Republicans do not.
Yeah, it is not accurate to say Democrats support the Voting Rights Act and Republicans do not. We're talking about a particular application of Section 5 of the Voting Rights Act that, based on its implementation and based on the failure to update findings, was leaving some states unconstitutionally, in the judgment of the Supreme Court of the United States, in a different position.
I happen to disagree with that opinion. You see it differently. Senator Hirono by remote. Senator Hirono is not available?
No, I am available. Mr. Chairman?
Yes, you have 5 minutes, Senator.
I'm so sorry. I thought Senator Blumenthal had been called. So thank you. I am here.
Many are called. Please proceed.
And some actually answer and show up. Okay, this is for Ms. Eiffel. You noted that the average length of Section 2 cases is 2 to 5 years, and it's simply not sustainable. And that is why we need to pass the John Lewis Voting Rights Act. So perhaps you can tell me, how effective is the current Section 2 in protecting people's right to vote in comparison to the pre-clearance process that was in place under Section 5?
Thank you very much for that question, Senator Hirono. So let me clarify also, just given the last colloquy, the Supreme Court actually invited Congress to update the formula under Section 5. It did not strike down Section 5. And so I'm very hopeful that Senator Lee and others are willing to participate in a process to update the formula so that we can pass a new preclearance formula under the Voting Rights Act. The difference is that the preclearance formula allows us to stop discrimination before it happens by introducing a federal process that allows for a neutral review, whether the federal authority is Republican or Democrat in terms of the Attorney General or the district court in DC, to review an election law to determine what its racial impact would be. And that would happen before the law would be passed. Every provision of SB 202 would have gone through that process before it became law. Instead, the law was rushed through. It now exists. We have filed suit along with other organizations. We will litigate that case likely for more than a year. And during that time, there will be elections in Georgia. As I said, in the Texas case, we were still litigating in 2018 a voter ID law that was enacted in 2014. If we think that that's appropriate for a healthy democracy to hold scores or hundreds of elections in which potentially hundreds of thousands, if not millions of voters are affected, and that law may ultimately violate the Constitution or the Voting Rights Act or the Americans with Disabilities Act or any of the other reasons why voting changes have been struck down, then I think that's what this committee has to really focus with. As a matter of democracy, we need to deal with these matters before they become law.
I agree with you, Ms. Eiffel. In the meantime, though, the Supreme Court has before it 2 cases that test Section 2. And I know some of the arguments that the opponents of Section 2, they would like to very much limit the impact of Section 2. Bad enough that the Department of Justice under the Trump administration brought how many Section 2 cases?
I think it's 0, if maybe 1.
I think that the 1 would be about it. That would be the maximum. So it's hard enough under Section 2, but some of the arguments that were made, if the Supreme Court goes along with the arguments that were made to limit Section 2, that would make it even harder. You would have to show different impacts. You would have to show much more than what you currently have, which is hard enough to do under Section 2. Would you agree?
It would be utterly devastating. It would be utterly devastating, a blow to our democracy, a blow to one of the finest moments in this country, which was the passage of the Voting Rights Act in 1965. And when the Senate passed the Voting Rights Act in 1965, they were very clear that they meant to get not only current forms of discrimination that existed in 1965, but the Senate report said it was also designed to get at ingenious forms of discrimination that might be created in the future. Congress was forward-looking. They understood that voter suppression would not go away. And to wipe out that history would be an affront to every martyr of the civil rights, voting rights movement, to Senator John Lewis, and to the many Black voters who actually feel demeaned when they're told that they can't give water to their elderly relatives standing on a line trying to vote.
That is what I call the kind of cruelty that is exemplified too often in these kinds of cases. So the Shelby County decision was a 5-4 decision, and Justice Ginsburg famously wrote, quote, "Throwing out preclearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you are not getting wet." Are you concerned that this court, with these 2 cases before it, will render possibly a 6-3 decision to further limit the Section 2 remedies?
Senator Hirono, I sincerely hope that the United States Supreme Court has seen what has happened since 2013 when the power of Section 5 was gutted, that they will understand, that they will be humble enough to recognize that there are things perhaps they did not know or understand that are happening in this country, and that they will read the record, that they will take account of what the reality is, and that they will respect what I believe President Reagan called the crown jewel of civil rights legislation, the Voting Rights Act, and ensure that it remains intact and an effective tool for combating voting discrimination.
Ms. Eiffel, I appreciate the dialogue I had with you, and I really appreciate the other, of course, Stacey, Abrams, and Ms. Anderson, whose books I read, and the others who have testified for the enactment of the John Lewis Act. I just want to mention one more thing, though. I've heard some comparisons to Hawaii voter laws and saying, well, Georgia is better than Hawaii. Oh, give me a break. For the first time ever, Hawaii had all mail-in ballots the last election, and we had the second highest percentage of voter participation as a result. This is why mail-in voting is so important, and why we need to look at what the post office was doing in the 2020 elections that made it that much harder, and the person who heads up the post office is still there. He needs to be removed. That is an editorial comment. Thank you. I think my time is up.
Thanks, Senator Warnock. Senator Cruz.
Thank you, Mr. Chairman. Ms. Abrams, it's been over 2 years, and you still refuse to concede that you lost the race for governor in Georgia in 2018. You have said that, quote, you do not concede that the process was proper, and that, quote, they stole it from the voters of Georgia. Yes or no, today, do you still maintain that the 2018 Georgia election was stolen?
As I've always said, I acknowledged at the very beginning that Brian Kemp won under the rules that were in place. What I object to are rules that permitted thousands of Georgia voters to be denied their participation in this election or to have their votes cast out. And so I will continue to disagree with the system until it is fixed. We have seen marked progress made, and unfortunately it was undone in SB 202, but I will continue to advocate for a system that permits every eligible Georgian to cast their ballots.
Ms. Abrams, I'm going to ask you to please answer the question I asked, which is, do you, yes or no, do you still maintain the 2018 election was stolen? That's your language.
My full language was that it was stolen from the voters of Georgia. We do not know what they would have done because not every eligible Georgian was permitted to participate fully in the election.
So you also told the New York Times that your loss, quote, was fully attributable to voter suppression. Ms. Abrams, do you know in Georgia whether the percentage of African-American Georgians who are registered to vote and who turned out to vote, is it higher or lower than the national average?
It is higher than the national average because Georgia is one of the largest states with an African-American population.
But that's not tied to the size of the population. The percentage of black Georgians who are registered to vote in 2018 is 64.7%. That compares to 60.2% as the national average. The percentage of Georgians who voted in 2018, the election you claim was stolen from you, was 56.3%. That's higher than the national average of 48%. Let me ask you this, Ms. Abrams. In 2018, do you know which demographic group in Georgia had the highest registration percentage and the highest turnout percentage?
I have a guess, but I will defer to you for the answer.
The answer is African Americans had the highest registration and the highest turnout, despite your claiming that the election was stolen and there was somehow voter suppression. Let's shift to the Georgia law in particular, which there have been mountains of lies spread by both Democratic politicians and by the press. Does the Georgia law reduce the number of early voting days? Yes or no?
Yes. It does so because you have to look at it in toto. It is not simply looking at the number of days that were expanded for 40% of the population, which for 60% of the population had been the norm. It also has to look at the early voting runoff days that were indeed shortened. If you add together the total number of days. Is it correct that the law increases the number of mandatory days of early weekend voting? It is a partial answer to say that certain days were increased in certain counties that had not participated in the use of all of those days of elections. They had been optional, and most 60% of Georgians had been able to vote for those full number of days. 40% will now join, and that is a good thing. But at the exact same time, this same bill eliminates weeks of early voting during runoff elections and limits and allows the elimination of weekend voting.
Do you believe that requiring an ID to vote suppresses votes?
As I have said, written, testified, and have repeated today, I believe that voter identification is always appropriate. You should know who is voting. What I object to are the ways that we are narrowing and restricting who has access to the right to vote, and that has been a common and necessary complaint. As we noted in 2018, what happened to Native Americans in North Dakota who were denied the right to vote because they were required to have photo identification that included language and included perquisites that they were not entitled to demand. When we have narrowing of opportunities without expansion of access, that is absolutely wrong, and I will stand against it in Georgia and everywhere.
During the 2020 election, did your organization, Fair Fight, collect ballots for voters? And if so, were the people collecting ballots for your organization paid?
We did not collect ballots. We did not pay people to collect ballots. We sent to voters absentee ballot applications, as did the Secretary of State, as did a number of other organizations, because in the midst of a pandemic, we thought it was important for voters who may or may not have had information about what their rights were to ensure that they had the education and opportunity for engagement in our elections.
So I want to be clear about your testimony to this committee. Your testimony is that your organization did not pay any person in the state of Georgia in 2020 to collect ballots for anybody else.
No, sir.
Okay, thank you.
From Georgia, Senator Ossoff.
Thank you, Mr. Chairman, and thank you to our panel for joining us. Mr. Chairman, I'd like to enter into the record a number of statements which may clarify for some of our colleagues the motives and circumstances that led to the passage of this infamous law in Georgia. Without objection. This is Georgia's Republican Lieutenant Governor, Jeff Duncan, who said about the law, quote, "This is really the fallout from 10 weeks of misinformation that flew in from former President Donald Trump." He further said, "There is solutions in search of a problem. Republicans don't need election reform to win. We need leadership." That was on Meet the Press. He further said in an op-ed in USA Today, knee-jerk reaction legislation, such as not allowing the distribution of water within 150 feet of a polling station just to appease the extreme right corners of legislators' districts and to avoid primary challenges. Ms. Abrams, in the exchange that you just shared with Senator Cruz, the question of early voting opportunities was raised. Can you please clarify for this committee what has changed about early voting and runoff elections in Georgia under this new law and what the impact might be of those changes?
Certainly. In the state of Georgia, previously, the law said that elections occurred during business hours. Most 60% of voters were able to vote between 7 a.m. and 7 p.m., which is the hour of operation on election day. And so for the majority of Georgians, the time allowed was from 7 a.m. to 7 p.m. The law now mandates that it be 9 to 5 p.m. with the option. The challenge with an optional permission is that it is no longer a given, and we have a number of counties that have taken options as an opportunity to restrict access. We celebrate the fact that more voters will have access to weekend voting, but it is not an expansion of a right when 60% of Georgians previously enjoyed that right. We know that 78% of Georgians were able to vote. The actual days and weekends. We know that 78% of Georgians were able to vote during those earlier voting hours, and that's what's being constricted. We know that, for example, in the state of Georgia, we have 159 counties, but some of our counties have as small a population as fewer than 2,000 persons. And so it is insufficient to simply look at the number of counties participating. You have to look at the populations that are participating. And we know in the state of Georgia that this law is restricting access to the right to vote. We also know that the optional notion of a Sunday vote, for example, was something that counties felt that they had the right to do. And we had a number of counties that were already using Sunday voting. So yes, to the extent that it is clarified in the law, that is one thing. But to claim that it is an expansion of access for the majority of Georgians is not only untrue, it is misleading, and it is false.
And isn't it the case, Ms. Abrams, that under this new law where there were previously 3 weeks of mandatory early voting and runoff elections, now there's just one?
Yes.
Ms. Abrams, Fair Fight Action, your organization, has issued an extraordinary report documenting the history of voter suppression in Georgia, which accelerated, as we've discussed in this hearing, following the Shelby County v. Holder decision of the Supreme Court, which ended the pre-clearance functions of the Voting Rights Act. Since 2013, since that Supreme Court decision, Georgia has closed hundreds of polling places, and the average distance voters have to drive to go vote has more than doubled. And not surprisingly, according to a nonpartisan analysis by the Atlanta Journal-Constitution, black and brown voters have been impacted the hardest by many of these changes and are 20% more likely to miss voting in an election because of the long distances they're forced to travel. And Mr. Chairman, I'd like to enter this Fair Fight Action report, Georgia's Enduring Racial Discrimination in Voting and the Urgent Need to Modernize the Voting Rights Act, into the record, with your permission.
Without objection.
Ms. Abrams, can you explain why the closure, the changing, and the consolidation of voting locations without DOJ preclearance can be so harmful, and why the John Lewis Voting Rights Advancement Act, which again, to just remind everybody on this committee what we're here to discuss, we are talking about restoring Section 4 and Section 5 of the Voting Rights Act, so the Department of Justice Civil Rights Division will pre-clear changes to election procedure and law that may have disparate, disproportionate racial impact. Ms. Abrams, why is restoration of the pre-clearance function so vital to ensuring harm is not done by the closure of polling locations such as those we've seen in Georgia over the last decade?
So over the last decade, we've seen more than 214 polling places closed. We have seen a number of consolidations and a number of shifts. We saw in Clayton County at one point an attempt, sorry, not in Clayton County, in Macon-Bibb County, an attempt to move a polling place from a location that was a publicly neutral place to a police station, which was going to have a deleterious effect on the likelihood of voters of color going to vote if they had to go to a police station to cast their ballots. We know that in the state of Georgia, under 2019 analysis by the Atlanta Journal-Constitution, that the closure of polling places, given the sheer size of Georgia and the increased distance that people have to travel without access to public transportation, led to between 54,000 to 85,000 people who were not able to cast their ballots, and black voters were 20% more likely to be affected by these closures. Taken together, the elimination or the changing of polling locations without accommodating those changes for communities that do not have access to public transportation, do not have cars, do not have the ability to drive. This changes their ability to participate in our elections. And I do want to clarify something I said earlier, Senator, with your permission. It is not that state legislators can change the composition of the SEB boards on their own motion. It is SEB itself. I did want to clarify that. But writ large, the way these laws are written with pre-clearance, instead of being able to wholesale remove access to voting locations, these voters would be protected by a process that looks at things like distance, cost of travel, access to transportation, and the ease of voting being either expanded or constricted. And it should always be our intention in the United States to increase access to the right to vote, never to restrict it.
Thank you, Ms. Abrams. Mr. Chairman, request one more minute.
I'm sorry.
Request just one more minute to ask a follow-up question.
Yes.
Thank you. Ms. Abrams, the closure of these polling places and the changes of polling locations at the last minute, which anybody who's run for office and anybody who's voted in Georgia knows is common, causes all kinds of confusion, leads people to show up at the wrong precinct, often through no fault of their own. And again, I want to clarify for my colleagues on the other side who have taken a genuine interest in the contents of this new law in Georgia, exactly what these changes mean. And I hope that this is clarifying. Under the prior law, voters who showed up at the wrong precinct because of closures or changes could cast a provisional ballot at that precinct. Under the new law, if they arrive before 5 p.m., they are forced to go to a different precinct, to travel in some cases across town. In some of these counties, to travel up to an hour to a different precinct in order to cast their vote or risk disenfranchisement. Ms. Abrams, what does this change in the new Georgia law mean for voters who rely on public transportation to vote or have their kids with them, or have a shift that they can't miss at work?
It presumes that people who vote before 5 p.m., that those people have universal access to transportation, to information, and the ability to change their behavior. But let's assume that you get into line at 1 p.m. and you get to the end of the line at 4:58 p.m., only to discover that you have used all of the time you have before your 6 o'clock shift to cast your ballot. It would no longer permit you to cast a provisional ballot, which was put in place under HAVA by this very Congress to solve for this problem. Those out of precinct provisional ballots would be discarded. And that is inappropriate because these are not people who are making the choice not to do what's right. During the 2020 and 2021 election, as you know, Fair Fight had volunteers standing in front of polling locations, directing people to new locations because they had been given misinformation or had not received information. And we know of a number of counties that changed their information. And while this new law attempts to address it, we know that the law has not been tested, and thus we do not know that voters will be protected. And to penalize voters before we know the protections necessary for their benefit are in place is anti-American.
Thank you, Ms. Abrams. Thank you, Mr. Chairman.
Thank you, Senator Ossoff. Senator Hawley.
Thank you, Mr. Chairman, and thanks to the witnesses for being here. Ms. Jones, can I just come to you? We have heard an extraordinary number of lies told about this law from the President of the United States all the way down, certainly including members of this committee, including today, and also from an unbelievable assortment of for-profit corporations. This has been one of the most incredible organized campaigns by these mega corporations in American history to try to influence legislation and ultimately to overturn it. And of course, these same corporations are now taking this effort to states across the country, no doubt soon coming to mind, to the state of Missouri, where we have our election integrity measures adopted by our voters in our legislature and also by referendum will soon, I'm sure, be in their sights. Let me just ask you about these lies that have been told over and over. The President of the United States, his big lie, that this legislation cut off the amount of time, closed the polls early. That was a lie. We've heard that water is not made available to people waiting in line. That's a lie. We've seen it told over and over and over. But I want to zero in on the corporations, their unprecedented power. Tell me, why do you think these corporations, so many of them, have been so eager to parrot lies that they know are not true? It's not like they don't have whole teams of lawyers. These are the most powerful corporations in the world. They have entire legal departments at their disposal. Why do you think they've been so eager to lie over and over about this law that your legislature adopted?
Well, thank you, Senator, for the question. You know, I can't speculate precisely on their motivation, but I can say that if they do have teams of lawyers and people to analyze the bill, their unjustified outrage is really ridiculous. And I believe most of these corporations, if they read the bill and compared our voting laws to most of the rest of the state, they would know that Georgia has an expansive system of voting. We've made it more expansive. And I must clarify, Senator, that Georgians always have had, for decades, the ability to offer early voting, or not decades, as long as we've had early voting, the hours of up to 7 to 7. That continues to be the case. What we did was counties that offered fewer than 9 to 5 early voting hours, we've required them. 134 more counties will offer longer early voting. But it has been disappointing to see some, and I will just say it, some in the business community either not read the bill or feel that they would be punished somehow by some of these enormous nonprofit organizations that have placed a lot of pressure on them.
Let me just ask you about some of the pressure tactics that these corporations have brought to bear. We've seen in public what they have done. We've seen the statements that they have made and the lies that they've told. Tell me about the companies, what they've been doing in the legislature. I'm sure they have teams, fleets lobbyists, just like they do here in this Capitol.
Right.
What are the sort of tactics that they have used there in the legislature to try to influence, intimidate? I mean, just give us a sense of what's been going on.
Well, I will say I worked closely on the bill and participated in the writing of every word of it. And I can say I was quite surprised by a couple of the companies' outrage, given that I never heard from a single one of them. And if they had, particularly, well, let me also say that by a couple of the chambers of commerce, the very provisions that they wanted retained in law were retained. And in fact, we went further by requiring now 2 Saturdays of early voting, whereas previously it was only 1 Saturday of early voting. So we expanded the ability for voters for early voting to vote, but yet I honestly, Senator, cannot explain their reaction other than to say they must fear some of these organizations that have an unbelievable amount of money. We've seen about $10 million spent already in Georgia inaccurately portraying this legislation. And as you know, if you say something often enough, however inaccurate it is, there are those that will begin to believe it. And so perhaps they've been influenced by that.
So what you're saying is that many of these corporations that are now howling in public and are spreading active disinformation in public and lies, they actually had nothing to say earlier, but now they are out there denouncing the law, calling it voter suppression, calling it Jim Crow, and when they had the opportunity to actually shape the bill or work on the bill, they didn't. But now they're mounting a public pressure campaign. Now they're saying they're going to go work in other states. Now they've changed their tune and are trying to ratchet up the pressure. Have I got that right?
Well, I would just clarify by saying that the few provisions, if the chambers of commerce were representing their interest and they were not communicating with us specifically, we retained those provisions, like 3 weeks of very expansive early voting, and in fact expanded the number of hours available. We kept no excuse early voting, which I'm sorry to say, Delaware in particular, the president's state, does not have, and it neither has early voting. So we retained the few areas, and I supported those provisions. What I mostly hear is not facts from those who are, to use your word, howling about the bill, but rather incendiary, just propaganda that doesn't at all align with the facts of the bill.
Mr. Gardner, let me come just briefly to you and ask you here, thank you first of all for being here, and just ask you about a statement you recently released about H.R. 1. You said, and I'm quoting you now, "Our state constitution requires that a voter must be present to vote unless a voter is absent from the town or city or physically disabled. This would also be taken away with H.R. 1. Contrary to our Constitution, H.R. 1 would require no excuse absentee voting, early voting with multiple election days, and continuing to receive and count ballots after the election." Just give us a sense of why these provisions are that are in your Constitution are so important in your view for election security in your state.
Yeah. Repeat the question. Okay, was that for me?
Yes.
Oh, I'm sorry. Well, they're important for New Hampshire because it's what has made our turnout what it has been. It's a combination of the trust in the process and the ease of the process. If you take that away from New Hampshire, then we're not going to have the turnout that we have had over the years. And I had mentioned earlier that the conventional view that anything that makes voting easier will increase the turnout. But those charts that I've provided, you can see the facts. It's that is just not the case. You know, many academics say that Oregon is the state that is the easiest in the country. As everybody has mailed the ballot, they have multiple days, multiple locations, but when Oregon went to that process, they have had a lower turnout than New Hampshire, 7 presidential elections in a row. And before that, when they didn't have it, they were ahead of New Hampshire, 5 presidential elections in a row. And so the states are different. The states have integrity is important. The belief that the process is honest is important. It's a fine balance. And all the states try to attain that fine balance, trying to work with a process that keeps people trusting, because if they lose trust in it, they're not going to bother. If it's not of any value to them, it doesn't have anything meaningful for them anymore, they stop doing it. And we're always striving to reach that sort of mid-ground, that people can trust it, but it's also easy. And we've had the 3rd highest turnout, 4 presidential elections in a row based on voting age population. We were 4th, the presidential election before that. And you can see in the charts that I've given you, you can look at all the states. It works for New Hampshire.
Thank you,
this would
Senator.
take
Mr.
away.
Gardner, thank you very much for your testimony. We appreciate that. Senator Blumenthal.
Thanks, Mr. Chairman. I'm intrigued by the argument that corporations should have been sooner in their opposition to these restrictions on voting rights, and that their social conscience was overdue, or that they needed legions of lawyers to tell them that these restrictions infringed on the franchise and curtailed the voting opportunities of people in Georgia. The fact of the matter is, as has been established irrefutably and powerfully today, these restrictions will impact adversely and enduringly the rights of citizens in Georgia and other states where they're being imposed. And the positions of the corporations really are beside the point. What's important is the effect on voters and their rights. In Shelby County, the Supreme Court tossed out the preclearance provision of Section 5 of the Voting Rights Act, which for decades served to protect communities of color from voter suppression. As the late Justice Ginsburg noted in her dissent, quote, "Throwing out preclearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you are not getting wet." And what we're seeing in Georgia right now and in other states around the country in those 361 restrictive laws that have been imposed is beyond a rainstorm. It is a tsunami threatening democracy. And we are here because of the Supreme Court's decision in Shelby County and the current torrent of voter suppression bills. So I think we must act, we should act on the John Lewis Voting Rights Act and the For the People Act, which would work in tandem. And let me ask you, Ms. Iffel, how, in fact, would they combine to protect voting rights in Georgia and other states where they are threatened?
Thank you, Senator Blumenthal. If you look at the core provisions of H.R. 1, particularly those that relate to automatic voter registration, early voting, absentee voting, they go right to the heart of the provisions that we've been spending the morning talking about here in the Georgia bill, and to many of the provisions that are being teed up in other states that will restrict access or burden access to the vote. The Voting Rights Advancement Act, the John Lewis Voting Rights Advancement Act, would require that voting changes, that where jurisdictions want to make changes to voting, where they want to consolidate polling places or eliminate polling places, where they want to impose new voter purge regimes, where they want to impose new laws, that those laws first have to go through the scrutiny of a federal authority. So one aspect of it in H.R. 1 would create a regime that would immediately provide for greater access to voters across the country by expanding registration, early voting, and absentee voting, and the other would protect voters against discriminatory voting changes that are proposed by state or local jurisdictions. And we need both of those elements to strengthen our voting system and to protect, in particular, minority voters.
I think that answer is very, very important because it shows that the effects of Shelby County are more than just changing the location or reducing the number of polling places. It is an effect on the entire system on access to the ballot box. I was very critical in the Georgia runoffs when there were sweeping attempts to suppress the vote through disinformation and intimidation online, particularly targeting communities of color. In fact, I wrote a letter demanding that Facebook and Twitter take stronger action to fight disinformation in those runoff elections, including fact-checking, labeling, and reducing the spread of information. I'd like to ask both Ms. Abrams and Ms. Iffel, how would you grade Facebook and Twitter for their handling of the spread of disinformation during the Georgia runoff elections?
Well, I'll go first very briefly. I've been in a years-long conversation with Facebook in particular to address the issue of misinformation on the platform. We believe this is yet another form of voter suppression. Facebook is used very much by African Americans, and we've had an ongoing conversation. What we've asked Facebook to do is simply to apply their own policies. They have policies against misinformation in voting, policies against voter suppression, and we have really pressed them to have a more aggressive and clear internal infrastructure to deal with these matters when they occur. It wasn't just in the special election. I recall actually something that really disturbed me. This was not on Facebook, this was on Twitter, when during the counting of ballots in Georgia after the November election, when the former president was discrediting the process, the license plate of a ballot counter was posted on Twitter by someone who wanted to stop the count and to undermine the legitimacy of the election, something incredibly dangerous to those people who were so bravely just doing their civic duty and counting ballots. So I think there's a long way to go. I think that there were certainly improvements over the last few years on both Facebook and Twitter, but there's still a ways to go to make sure that the platform does not allow for the kind of misinformation and intimidation that we saw in 2020.
Thank you, Senator.
And I would simply agree with Ms. Eichel.
Thank you very much, Senator.
Thank you. Thank you, Mr. Chairman. Still a long ways to go. Thank you.
Thank you. Senator Cotton.
Ms. Abrams, I want to talk about your role in the decision by Major League Baseball to boycott the state of Georgia and move the All-Star Game at an estimated cost of $100 million in economic activity and thousands of jobs for Georgia's residents. On March 8th, when describing the Georgia election law, you called it Jim Crow and a suit and tie. On March 10th, well before the Georgia election law was passed, you registered the website stopjimcrow2.com. On March 14th, you called the Georgia election bill a redux of Jim Crow. On March 25th, the bill passed into law. On March 31st, you wrote an op-ed in the USA Today about Georgia's law, and your first two words in that op-ed were, boycotts work. 2 days later, on April 2nd, Major League Baseball announced its boycott of Georgia. According to media reports in the days leading up to Major League Baseball's decision to pull the All-Star Game from Georgia, you spoke with baseball executives, you described the law as Jim Crow 2.0, and you urged Major League Baseball to speak out. But after its decision to withdraw the game from Georgia, you conveniently claimed that you had strongly urged them not to boycott after the horse was out of the barn and the damage was already done. So, Ms. Abrams, in sum, you publicly attacked the Georgia law as Jim Crow no fewer than 10 times before Major League Baseball withdrew the game. You told corporations that boycotts work, and you told corporations that if they don't attack Georgia's law, quote, I cannot argue with an individual's choice to opt out for their competition, end quote. Ms. Abrams, after all these efforts to smear Georgia as a Jim Crow state, do you regret your central role in causing Major League Baseball to withdraw the All-Star game from Georgia?
First, Senator, I would not call Georgia a Jim Crow state. I would say that SB 202 is a law that has Jim Crow aspects, and I stand by that characterization because we have, I think, to great detail and great effect explained today why that is so. I also, in line 2 of that same op-ed, I acknowledge that boycotts work because as the progeny of those who used boycotts to gain access to the very rights we are fighting to defend, I recognize the utility of boycotts. However, I took a great deal of effort to explain why I do not think a boycott in Georgia at this time is the appropriate remedy. But I believe it is important to preserve all civil disobedience rights when you seek to achieve the outcome of justice and access in the United States. Number 3, I would say that my conversations with Major League Baseball were very clear about the fact that I did not think a boycott was necessary. I was very intentional about my language. I continue to be intentional about my language. And while I am not the commissioner of baseball, I'm not the head of a corporation, I am a Georgia citizen, and I have every right and responsibility to speak out against laws that will have an effect on my community. And yes, well, I certainly regret the decision that MLB made to remove their game from Cobb County and the economic effect that it will have on Georgians writ large. I support anyone who will try to stop this type of bad behavior, this type of racial animus, this type of voter suppression from happening in Georgia or elsewhere in the country, because to me, one day of games is not worth losing our democracy.
Thank you, Ms. Abrams. After you spent weeks condemning your legislature for passing Jim Crow laws and telling corporations boycotts work, I doubt that your words are going to be very comforting to the thousands of Georgians who will lose their jobs or will have their livelihood affected by Major League Baseball's decision. I want to turn now to Secretary Bill Gardner. I want to stress again that he's been in office since 1976, longer than 3 members of this committee have been alive. Back in the Army, we had a term for grizzled soldiers who had been in combat repeatedly, not just Afghanistan and Iraq, but sometimes Mogadishu or Panama, or I even served with one guy that jumped into Grenada in 1983. They were called been there and done that. If anyone has been there and done that when it comes to election laws, it is Bill Gardner. You have repeatedly, over decades, reviewed election laws. You see what is before the Congress now in the For the People Act with its sweeping reforms. What do you think this federalization of our state-based election system would do to your elections in New Hampshire, Secretary Gardner?
Senator, it would be harmful to our elections in New Hampshire. I go back when the FECA, Federal Election Campaign Act, originally passed, and there was a threshold. States that met the threshold weren't going to be affected by it. And then within 2 years, states were completely taken out of that. We no longer could control the rules for the election of our U.S. senators and House members. Then we went to the National Voter Registration Act in '93. And that act, people of New Hampshire, the local officials, wanted voter registration to be an in-person process. And the only way to maintain that in-person process was if we became exempt from the National Voter Registration Act. And so we passed legislation, made it retroactive to the effective date of that act. That was the only way to get exempt so that we could keep our election process the way New Hampshire wanted it. And we were sued, not by anyone from New Hampshire, because both parties were agreeable then, but from some organization in New York City. And we ended up, the federal government gave an exemption to us so that we no longer had to comply with NVRA. That's made all the difference. If you look at the chart, you can see what happened in New Hampshire starting in 1996, the first time a presidential election happened after the National Voter Registration Act. And New Hampshire, from that point on, has been at the top of the country because we don't allow people to register by mail unless they're absent, they're out of town or out of the city, or they're disabled. We have our rules that we've applied all these years, and you can see what it has resulted. 4 presidential elections in a row, 3rd highest in the country. The one before that, 5, we were 4th in the country. Then you can go back, you can see from those charts. So then we went to the Help America Vote Act. Well, we became exempt from parts of NVRA because we were exempt from NVRA, we didn't have to comply with the Help America Vote Act. We don't have provisional ballots in New Hampshire. We're one of 4 states in the country that doesn't have provisional ballots. So we've gone our way that has worked for the people of New Hampshire. The proof is in the pudding, the turnout. And it's the same with this. Now they want to, if you were to pass this, you're completely taking away a process that has developed in New Hampshire for many, many years, works in the state. Why would you want to do it when the turnout is as high as it is? And as I'm listening to all this, it's a pretty sad story in a way, because you have the state of Georgia. There's a New England state, Rhode Island, that actually had a lower turnout in 2020 than Georgia. But states have different ways of doing it that works. That's why I said at the beginning, I don't want Texas to have to be like New Hampshire or Arkansas or California, but why should we be made to be like California in particular, or other states? We have a way of doing it that works for the people of New Hampshire. The turnout is the proof that it works. And this kind of federal legislation is harmful for our way of voting.
Thank you, Mr. Gardner. I appreciate your testimony.
Thank you, Mr. Secretary.
Senator Booker?
Thank you, Mr. Chairman. Stacey Abrams, I'd like to direct some questions to you real quick. I just wanted you to continue to specify the difference between absentee ballot IDs and in-person voter participation. I think this thing's been muddled in that, and I would really appreciate it if you gave some, again, clarification why the Georgia laws are limiting particular voters' access.
So if you think about thank you, Mr. Senator. When you address the issue of voter identification when you are walking to a polling place, you are demonstrating who you are for the purposes of receiving a ballot, but you are not asked to surrender that piece, that proof. You are not asked to give it to a poll worker who will then be able to retain it in perpetuity. You show it to prove who you are, and then you proceed to the voting booth. Georgia, for 15 years, had a similar situation with regards to voting by mail, but instead of requiring you to put identification in an envelope that will be clearly marked for anyone seeking to steal your identity, it instead said you could use a signature verification process. We took exception to some provisions of the signature identification process after 2018, and in 2019 and 2020, those changes were made to make it more equitable and fair for all participants. That was a change that was necessary, and it worked. In fact, it worked so effectively, we saw more people successfully participating voting by mail. But to now change it to an identification process where you have to surrender your identification, you have to surrender it in an envelope that is clearly marked for anyone seeking to steal your identity, that they can open that envelope and get signifying information about you, either a photocopy of your information or distinctive numbers that will allow them to steal your identity, is absolutely troublesome and should create deep fear in any person considering this. It is not an apples to apples comparison. There is no other form where we say that these pieces of information will sit in a box or sit in an office there is no provision for how long and who can have access to it. It is a very real difference with an absolute distinction that can cause harm to voters. In addition, signature mismatch allowed for those thousands of voters who admittedly do not have the requisite identification to submit. It gave them an alternative process to use, and it has worked for 15 years. There is nothing that occurred in 2020 and 2021 to discredit that process, except that it finally worked for most voters. And in particular, voters of color, for the first time in Georgia's history, successfully used it to actually help change the outcome of an election. My challenge is not with whether it's a Democratic victory or Republican victory. It is that it is a harm to voters and disproportionately will harm voters of color who are the most likely to lack the identification. But we should also be deeply concerned about disabled voters and older voters who are now going to have to sacrifice their personal private information in order to participate in elections. And that should be deeply concerning to every American.
Thank you, Ms. Abrams. Really quickly to Sherilyn Ifill, just in terms of the landscape of our nation on voter ID laws and with regard to challenges to voters, how does the Georgia bill fit into that? And can you give us, in my final 1 minute and 20 seconds, just a vision of what the landscape looks like and why this is so concerning in terms of the changes we're seeing and the effect they're going to have on the right for franchise?
Thank you, Senator Booker. I think people do confuse this idea of ID as though we're talking about all one thing. So first of all, Georgia is now one of only 4 states that requires this photo ID for absentee voting. Yes, many states require voter ID, but not all states require government-issued photo ID. So there are 12 states that require ID, but it's a non-photo ID. It can be a utility bill. It can be other forms of identification that connect you to your address. There are some states that require no ID to vote unless you are voting for the first time, and those include Maryland and Massachusetts, Minnesota, Pennsylvania, Vermont, West Virginia, and of course then there are the vote by mail states, Oregon and Washington. So it's really important to understand that when people talk about whether you're for or against ID, there's ID and there's ID. The question is, are you requiring people to have the kind of onerous ID that you have to get by going to the Motor Vehicle Bureau? Even if the ID is free, you have to pay sometimes to get your birth certificate because you may not have it. You have to travel to a Motor Vehicle Bureau in the 21 contiguous counties in the Black Belt in Georgia. The motor vehicle offices are only open 2 days a week. Some only open 1 day a week. So that's really the concern about the ID. It's the kind of ID that is required, and we should not presume that all states that require voter ID require government-issued photo ID. They require some form of ID to connect you with your address.
Thank you, Mr. Chairman. I will not encroach upon the time and yield to the great, kind, gregarious, wise senator from Louisiana.
I think I'm going to call on Senator Kennedy instead. Senator Kennedy.
Thank you, Senator Booker. You're a fine American, sir. Ms. Abrams, can you hear me? I don't know where to look. I hate these Zoom hearings.
Yes, sir.
In terms of voter confidence in our electoral system and perception of voter integrity and and election, let me start over. I'm sorry. In terms of the confidence that Americans have in their electoral system, do you think we're better off having an election day or an election month?
I think we are better off having a process that allows every single American the opportunity to participate in elections. And given that the initial notion of an election day was based on an agrarian economy that no longer exists for millions of Americans, and given the fact that we have a number of Americans who are limited in their access because in states like Georgia, there is no paid time off for voting, I think we have to make every opportunity to make voting accessible to every American. There is no other entity that
let me
would
stop
be
you
denied.
because I've got a bunch of questions before you get off the subject and get me off. So you're okay with us not knowing, say, weeks or months after an election who the winner is?
Yes.
Okay.
We have had times in this country where we have not known.
Talking about the Georgia bill, help me understand. And I'm not interested in a 30,000-foot view. That's not meant to be a criticism. I'm speaking to myself, I guess. I'm not interested in platitudes. Tell me, you're against the Georgia bill, I gather. Is that right?
I'm against certain provisions of it, yes.
Okay, and I think you've called it a racist bill. Am I right?
I think there are provisions of it that are racist, yes.
Okay. tell me specifically, just give me a list of the provisions that you object to.
I object to the provisions that remove access to the right to vote, that shorten the federal runoff period from 9 weeks to 4 weeks, that restrict the time that a voter can request and return an absentee ballot application, that eliminate
slow down for me, because our audio is not real good here.
Certainly.
Could you start over for me?
Certainly.
Thank you,
ma'am. It shortens the federal runoff period from 9 weeks to 4 weeks.
Okay.
It restricts the time a voter can request and return an absentee ballot application.
Right.
It requires that a voter have a photo identification or some other form of identification that they're willing to surrender in order to participate in the absentee ballot process.
If I can stop you, that's where they're going to not comparing signatures, but to voter ID?
Yes, sir. And as Ms. Eiffel has pointed out, we would become only the 4th state in the nation to require voters to put at risk their identity.
What else? What else?
It eliminates over 300 hours of Dropbox availability.
Okay, what else?
It bans nearly all out-of-precinct votes.
Bans what? I'm sorry?
It bans nearly all out-of-precinct votes.
Okay.
Meaning that if you get to a precinct and you are in line for 4 hours and you get to the end of the line and you are not there between 5 and 7 p.m.,
okay,
what else? To start all over again.
Is that everything?
No, it is not. No, sir. It restricts the hours of operation because it now, under the guise of setting a standardized timeline, it makes it optional for counties that may be may not want to see expanded access to the right to vote. They can now limit their hours. Instead of those hours being from 7 to 7, they're now from 9 to 5, which may have an effect on voters who cannot vote during business hours, during early voting. It limits the voting
Okay, I get
hours.
the idea. I get the idea.
Yes, sir.
Let me ask you this. Let me approach this another way. If a state decides to require a voter to prove who the voter says he is or she is, do you consider that racist?
Not at all, sir. Voter identification has been a part of the American theory of democracy almost from the beginning.
You're okay with it?
I support voter identification. Yes.
Okay. How about ballot harvesting? And I heard earlier you were talking about letting the tribal elders collect ballot. I'm not talking about that. I'm talking about where the parties, and believe me, both parties will do it and probably are doing it, pay operatives to go out and help people with their ballots and collect their ballots. Are you okay with that, or are you against that?
I don't think it's an either or situation. I think it depends on what the conditions are, what the rules are, but making it easier for those who want to participate in elections to do so with safely and securely, I think it's
So you're okay with ballot harvesting?
No, sir, I did not say that. I said, because that is a term of art that encompasses a wide range of behaviors. And even your example.
I'm sorry, but I'm trying to get down from the platitudes and understand what you're for and against.
But sir, what I'm for is
help me with this. Let's suppose that the Republican Party wanted to hire people to go out and knock on doors of voters and say, have you voted yet with your mail ballot? And they say no, and then the operatives are told to contact the voter and say, let me help you with your ballot. If you have any questions, I can even suggest to you might want to vote for. And after you vote, I'll collect the ballot for you and you make it easy. Is that okay?
Sir, I'm both an attorney and a former legislator, and it is not simply the words that you're saying.
I'm an attorney and a current legislator, and I might trade places with you, but keep going.
And so my point is, as you and I both know, that the context, the rules, and the structure matters. Now, in the very narrow circumstance that you just described, if there are no controls and if it turns into buying votes, of course I object to that.
Okay.
But if you look at the piecemeal components that you're describing, and if we are talking about how do we make it easier for voters to participate in elections, I'm not certain what that looks like, but what you described in this very specific and narrow construct, it sounds like you're in violation of a number of different rules, not the least of which is buying a vote.
All right, let me ask you one last question. Our chairman's really indulged me here. Do you think it was a smart thing for President Biden to do when he called everybody who supported the Georgia bill a racist?
I think that this bill is grounded in racial animus. I think that the language that we are using to describe
Can I ask
this
you how
bill,
you know that, madam? I mean,
Because
it's an honest question. How do you know that?
because for 15 years, the Republican Party of Georgia not only sanctioned but celebrated its vote by mail provisions. It was only after voters of color for the first time in 15 years successfully used those provisions in favor of the party that they disproportionately support that those rules changed. It is that for years, for more than nearly 2 decades, we had early voting hours that supported voters that were perfectly fine. It was only after communities of color used those provisions in
But why
excess
doesn't
of
that hurt black people and white people and brown people? This is what I'm
I
trying
think
to
it hurts everyone. If you've watched me, I have fought for the right to vote for every person.
I
No
agree.
one is
But
entitled to
that's a
victory.
long way from the president calling people a racist because they support a state.
Sir, I'm responding to the question you asked me. My point is that when your motivation is grounded in the race of those who are engaging in behaviors that you disagree with, that is racist, particularly when it is targeted at communities of color by people in power.
I agree with that. I agree with that. I agree with that. The chairmans have gavelled me. I just need to ask, how do you know that's what they meant?
Because we asked them not to do it because we showed them what the effect was, and they refused to answer, and they refused to abide. I worked with these people for 11 years. I don't believe that every single person who supported this bill has deep racial animus in their hearts for all purposes, but for the purposes of voting rights, when racial animus is your predicate, then yes, you should be held accountable, and those bills should be stopped.
Thank you. I'm sorry I went over, Mr. Chairman.
Thank you, Senator Kennedy. Senator Padilla.
I'm sorry, Senator.
Thank you, Mr. Chair. I invite my colleague, any colleague actually, who would like to discuss the intricacies of election administration. I'm more than happy to do so, having served as a chief elections officer for not just the most populous state in the nation for the prior 6 years, but home to the largest, most diverse and inclusive democracy of any state in the nation, even if it takes some alligator sausage and California wine to bring us together. Speaking of, Mr. Chair, I feel in many ways this hearing is a continuation of the quality conversation that was begun by the Rules Committee prior to the most recent state work period, of which I'm a member, as is Majority Leader Schumer, Minority Leader McConnell, and other leaders on this topic. And I raise that because in that hearing, some of our Republican colleagues raised the frame of working to make it easier to vote, but harder to cheat, as if it's some sort of mantra or guiding value. It was referenced that that was inspired by partisan action on election reforms after the 2000 presidential administration. They have seen and heard firsthand a lot of Republican secretaries of state in recent years use that mantra, easier to vote and harder to cheat. And in some ways, it's actually a helpful prism, because it seems like we've done a heck of a great job on the second part, the harder to cheat. Study after study, report after report, investigation after investigation continues to document that voter fraud in America is exceedingly rare. The easier to vote part still requires a lot of work. And I thank you, Mr. Chair, for prioritizing this topic for hearing in this committee today, and I hope action by Congress in the very near future. The easier to vote part requires a lot of work. I'll tell you what the signs are that we have a lot of work to do. The long lines that we see in multiple states on general election night. The movement in some states for fewer days or fewer hours or fewer locations to vote as time goes on. the shame in some states where we can debate the value added of a voter ID law, but when these laws are written in such a way that a concealed weapons permit allows you to get into the voting booth, but a state-issued state university ID does not, we know there's an agenda behind the impact of these laws, and on and on and on. I tell you what does help: amplifying, increasing the opportunity to vote by mail for eligible voters, as was done in New Hampshire, which was a big part of their increase in participation in 2020. I can assure you it was a big part of California's record turnout in 2020 as well, offering eligible voters more days, more hours, more flexibility of where to vote in person if that is their choice. The acceptance of more vote by mail ballots that are postmarked on or before election day, even if they arrive after the election. The implementation of post-election audits to continue to buttress election integrity, et cetera, et cetera. Mr. Chair, we have the playbook on how to strengthen our democracy, maintaining the security and integrity of our elections while facilitating more participation. But sadly, the term voter fraud, the potential for voter fraud, is used as a pretext to do the opposite. Now, several of our colleagues have also referenced how 2020 was an election year that saw record registration in most parts of the country, probably nationally as a whole, record turnout in many, many states across the country, nationally as a whole. And so why are the proposals making their way through Congress necessary? Well, you have to ask the same question when we see as of March 24th, 361 bills introduced in 47 states that would restrict opportunities to vote in our election. And I know some of our colleagues have said, well, just because they're introduced doesn't mean these measures are going to see the light of day. 5 have already been enacted, 29 have been passed by at least one chamber, and more still under consideration. Mr. Chair, that's a long preamble in the lead up to my main question for our witnesses here. And I begin with saying what more people should recognize, and that is that voter suppression is rooted in white supremacy. Now, during the Jim Crow era, we know that racially targeted and racially motivated voter suppression was often blatant. Legislatures adopted overtly racist policies like literacy tests and poll taxes in an effort to shape the electorate. Today's voter suppression playbook is still rooted in white supremacy and motivated by the same factors as their Jim Crow predecessors, but it looks different. Overtly racist policies have been replaced by facially neutral ones, like mandated in-person voting requirements, the decommissioning of polling sites, and manipulated discriminatory photo ID laws, as I've mentioned. But just because these new voter suppression tactics are facially neutral, it can be harder for people to recognize and understand their pernicious effects. So my question for Ms. Eiffel, Ms. Abrams, and Professor Anderson is simply, can you explain, can you share how these seemingly race-neutral policies nonetheless have disproportionate racial impacts?
Well, if I might begin, Senator Padilla, and thank you. Let's talk about a provision that we haven't talked about today, which is that this law, SB 202, provides for unlimited challenges to the legitimacy of voters. I'm sure many people are aware that there are organizations who make it their business to challenge voters to determine whether a voter, in fact, should have been able to cast a vote. Organizations like True the Vote. There were 360,000 challenges after the November election in Georgia. And the Georgia Secretary of State found that there were no substantial findings that supported any widespread voter fraud through those challenges. If that was the case, if 360,000 challenges failed to produce anything significant. Why does SB 202 now provide that anyone can make unlimited challenges to the legitimacy of voters? This is a form of voter intimidation that can often be used to target Black and Latino voters, to target voters who are from immigrant communities. What is the predicate? What is the underlying basis for that provision of the law? Why create this untrammeled system in which anyone can engage in these unlimited challenges to voters? We know that this will disproportionately be targeted at communities of color, and yet it is in SB 202. It is not connected to any evidence or predicate that it is necessary. It is not narrowly tailored. It is not designed to actually get at voter fraud. It is actually designed to create an unlimited system of voter intimidation that will be targeted at Black and brown voters.
Ms. Abrams?
I would only add that we know that of those 364,000 challenges, one of the provisions that are included in this is that the counties that were able to speedily dismiss these challenges for lack of evidence and lack of basis are now going to be penalized by the state if they do not engage in sham hearings that can serve to not only terrify voters, but often push them out of the process because they are unaware of how these processes work, and they could be terrified that if they participate, it could somehow imperil their ability to participate in work or otherwise. And so, as Ms. Eiffel pointed out, this is just one more example in addition to the number that we've given earlier that demonstrates just how difficult it is to behave with integrity when you are being attacked with impunity by those who use racial animus and your mere presence as a threat to democracy. And I would actually like to see the rest of this to Dr. Anderson, who I think most ably can connect the dots between Jim Crow before and Jim Crow 2.0.
Thank you so much. And thank you, Senator Padilla, for your question. The challenges that Ms. Eiffel has described were in these Jim Crow constitutions, such as the one in North Carolina, that allowed any voter, anybody, to go up and challenge the veracity, the validity, the legitimacy of a voter. That was intimidation. That kind of engagement, that kind of harassment is what we see replicated in this bill. I would also say that one of the things that we see is the limitation of drop boxes. The drop boxes were really designed to deal with a pandemic and designed to deal with the fact that the post office was being deliberately undercut in terms of its ability to deliver absentee ballots in a timely fashion. So the rise of drop boxes provided access to voters to be able to engage in this election process. What we see with SB 202, however, is an elimination in Atlanta, where the majority of Black voters are. You see that we go from 94 drop boxes to 23. And those drop boxes are now to be housed inside in buildings that can be closed. So this is how you can limit access to the ballot box while writing race neutrally laws. These aren't race neutral. They're not as race neutral as the poll tax was or as the literacy test was. Neither of those said we don't want Black folks to vote, but that was the underlying premise behind them, as Big Chief Vardaman made very clear. And that's what we're seeing right now with these voter suppression laws. It is in response to the massive wave of Black voter turnout that happened in the 2020 and 2021 elections.
Thank you, Senator Padilla.
Thank you, Mr. Chair.
Senator Tillis.
Thank you, Mr. Chair. Thanks to the witnesses for being here. Speaker Pro Tem Jones, thank you for your leadership in the Georgia legislature. I know a little bit about Georgia. Both my kids were born there. I lived in Atlanta. I got a lot of family down in South Georgia. Over the past several weeks, I've heard a number of reports. I've also heard several comments today that seems to me that we're not properly characterizing many of the aspects of Senate Bill 202, what would you consider to be some of the more blatant mischaracterizations that you've heard today or that you've heard reported in the press?
Well, thank you, Senator Tillis. Well, it would take me quite a while to go through the ones today, but I'll just go through a few of the most recent ones. No ID is surrendered to vote absentee. The exact same voter ID requirements that are in law and have been in law to vote in person are now simply going to apply to absentee voting.
Ms. Jones, how does that, Ms. Jones, if I may, how does that work? You know, if you go to a poll location, they ask for an ID, you have a government-issued ID or I guess other acceptable forms of identification. How does that mechanically work in a absentee process? Are they copied and submitted with a ballot? How does that work?
No, sir. If one has a pen, a ballpoint ink pen, and you can take the number on your driver's license or the number on your free voter ID, or I might add, I would like to clarify, someone said a utility bill couldn't be used. You could use any one, if you do not have one of those two, which 97% of Georgians do, you can submit a copy of a utility bill, for example, one of the federally allowed forms of ID. This is not a hardship. And
so, Ms. Jones, I just want to be clear because I got a lot of other questions I want to ask you.
Okay.
So when we hear people talking about an unreasonable requirement, in North Carolina, I think our driver's license number is somewhere around 8 or 10 digits. So you're saying
That's
provided
right.
that you have a writing instrument and you can write down 10 or 12 digits, let's say yours is a little bit longer, then you've satisfied the ID requirement on the absentee ballot?
Yes, sir, that is true.
People said that, I think it was Ms. Abrams that said she focused on the 9 to 5 window
Yes.
for voting. It sounds to me like in the law that was more or less established as a floor, and that you provided the options for local boards of elections to do 12 hours, 7 to 7 voting. Is that correct?
That is correct. We had 134 states that offered fewer hours than 9 to 5. And so it is expanding the number of hours available for early voting.
How
in
about
most counties.
the assertion that was mentioned by one of the other witnesses, I can't recall who it was, that said that providing water to your elderly parents or grandparents could get you in jail? Is that a part of this bill?
No, sir. The just as has been in long time current law and is in most states and probably your state, there is a protected distance that was frankly being gamed and manipulated during the last 2 election cycles by activists and candidates handing out items of value, sometimes with their logo on it, and this simply puts
right. So it's another mischaracterization. That's what I mean. All this stuff is mischaracterization. I think it's important to point out that in Georgia you have just under 4 weeks of early voting. Is that correct?
We have 3 weeks of early voting, which is quite expansive.
Okay, and that includes Saturday and Sunday option. Is that correct?
It mandates 2 Saturdays in Senate Bill 202. Previously, only 1 Saturday.
And the option for Sunday voting.
And two Sundays are absolutely available.
And
only, may I just say, Senator, only 16 counties utilized Sunday voting in 2020. Yeah. But all 159 counties are able to utilize it if they so choose.
Is the provision for drop boxes driven more by the logistics of where you can secure the drop box to prevent tampering? What was the
yes,
witness said you went from 90 to 24 in Atlanta, Fulton County area. Was that just based on
the numbers are somewhat
where you could have secure
different from
drop
that?
boxes?
I live in Fulton County, and there will be sufficient drop boxes, but we never had drop boxes before 2020.
Yeah.
They were purely put in place by the state elections board out of social distancing concerns. Well, I certainly am optimistic we won't have social distancing concerns at the time of the next general election, but should we have them, the law also allows for the state elections board to take them back to the way they were during the pandemic, which was outside of early voting locations. But for security reasons, we had drop boxes that were overflowing because they were not monitored. No one was watching the camera on them. This will make sure that every vote counts.
Well, that seems rational to me. Mr. Chair, I have to associate myself with Senator Lee's comment. You know, this has been a contentious hearing, and these sorts of hearings can be. This committee rightly has our members with our differences on it, but I really believe that we need to start getting the facts on some of this, on some of the voting laws. I don't think setting the premise with Jim Crow 2021 is a particularly productive way to get people to talk about states like Delaware that's only currently implementing early voting. States like North Carolina, we were the first to cast ballots in the last election cycle. You could start casting your absentee ballot in September. We do allow for weekend voting. We have a lot of early voting sites, and yet when I was Speaker of the House and the gentleman that went behind me have had those bills, even by members of this committee, being Jim Crow bills. And the fact of the matter is we've had increased participation among the African-American demographic and the minority demographic. There does seem to be a number of states that I'm sure we'll never have a hearing on here. I think Ms. Abrams even said they're behind the 8 ball. I think they're right. I think if we had some of the restrictions that we see in other states and southern states, then we would be probably rightfully insulted, and yet they get a pass. I hope that the people of Georgia and that the American people will get past some of the misinformation. The 361 bills has been referred to repeatedly in this hearing. If you look at it, I, for one, think cleansing voter rolls to prevent dead people from voting is not a bad idea. And if you start decomposing, if the record's going to be open, I'm going to provide something without objection that really breaks down these bills to say maybe some are going outside of the lanes, but not 361. These are games that are being played. I've got an article here that, without objection, I'd like to submit to where fundraising on aspects of the Georgia bill that never made its way into law. I don't even know if there was a serious amendment ever considered. It looks like a lot of people are creating a lot of noise at the expense of identifying legitimate areas where we feel like voters don't have the right to vote. I believe in North Carolina characterizing my laws, a law that I ratified, a law that was passed by almost 70% vote in a majority Democrat state. In fact, Republicans are third behind unaffiliated. Almost 70% supporting voter ID laws and integrity laws. I think that the Georgia law has more to do with election integrity than voter suppression, and I hope that we can get to a point to find the real offenders, weed them out, but not necessarily have these circular discussions where I'm sure fundraising emails will go out and people will be talking about protecting voter integrity, but they're not getting anything done. Speaker Pro Tem Jones and the rest of the witnesses, thank you for being here today. Thank you, Mr. Chair.
Thank you, Senator. Thanks for everyone for participating in this. Yes, Jim Crow 2021 is a provocative title. It certainly raised the interest level in this committee. The participation today is an indication of that. I think this is a serious issue. I'm glad that Professor Anderson was with us, though she may not have had as many questions as others. She put it in a historic context. There was a time in our history when people were boldly stating what their intentions were with efforts at voter suppression. Not so often now. And yet we have to be honest and take a hard look. Senator Tillis stepped out. Measures like a North Carolina law that required strict voter ID and limited early voting, which a federal court found, and I quote, targeted African Americans with almost surgical precision, close quote, and determined that the state legislature, quote, enacted the law with discriminatory intent. That is not from the 19th century, nor even the 20th century. It is modern times. Measures like a Texas law implemented mere hours after the Shelby County decision, a law that was ultimately determined to violate the U.S. Constitution by a federal court because it wrongfully discriminated against the state's Black and Latino voters. Here's what troubled me, and I tried to say at the outset. It appeared that the people who ran the elections in Georgia in 2020 were willing to stand up to the President of the United States when he personally called the Secretary of State Raffensperger, and in a veiled threat suggested he might be guilty of a crime if he didn't set out to find the votes necessary to make Donald Trump the winner in Georgia. And he resisted that effort. I respected him very much for it. I think it took a lot of fortitude on his part, particularly as an elected Republican. I understand he was criticized by many Republicans in Georgia, many of the same Republicans who then went into legislative session and passed this bill, and in the process stripped him of authority which he had before. He paid a price for standing up and saying that. And the troubling thing that's never been answered, and asked over and over and never answered, what was the incidence of voter fraud in Georgia that caused that legislature to come in and change so many versions of the voting law after 2020 and after the special election in 2021? There wasn't any instance of voter fraud. Senator from North Carolina raised the question of dead people voting. How often does that occur? Well, President Donald Trump said to Raffensperger, we think there are 5,000 dead people who voted on the rolls in 2020. Raffensperger's reply, there were 2, Mr. President. They were wrong. They never should have done it. But 2 out of nearly 5 million votes. It is just, it defies logic to think that we're in a position now where we are changing the laws of a state after it's produced record turnouts and after there's so little fraud and still the efforts are being made to make a substantial change. Do I understand Senator Blackburn is online?
Yes, Mr. Chairman. I had to leave the hearing and come back. And so, yes, I am available now.
Well, Senator, we were just concluding the hearing, but I want to give you your chance. So take your 5 minutes, please.
Thank you. I appreciate that. I want to say thank you to our witnesses because they've been incredibly patient with us today because this is such an important hearing from us. I'm one of those that served on an election commission before I was in elective office. I did that in my county. I know how incredibly important it is to make it possible for everyone to vote. Mr. Gardner, I appreciated your comments on how your focus is on making it easy for people to vote while still making those votes safe. And I believe everybody should have their opportunity to vote. I have a pickup truck, and for about 25 years, the license plate on that pickup truck said vote, because it was a way for me to send that message to everybody, register to vote. I will say it's been a little bit distressing to me today listening to this hearing. I got into the room for a few minutes to hear the premise of this hearing as if there is some assault on the right to vote in this country. And we know that we have had record voter turnout, and my colleagues across the aisle know that we have had record voter turnout in recent years. And this is to say that it's Jim Crow laws. In my opinion, that is not a valid premise. And I find it unfortunate that there are some who've continued to push that and push it on the state of Georgia. I think we have to look at the lead up to this and the things that have been said. Look at the Washington Post and their comments about President Biden when he falsely claimed that Georgia's recent voting reform law, and I'm quoting, ends voting hours early so working people can't cast their vote after their shift is over, end quote. And President Biden went on to describe Georgia's election law as, quote, Jim Crow in the 21st century, unquote, which appears to be the inspiration for this hearing. The problem is, as we've discussed several times, the Washington Post gave President Biden's remarks on this issue 4 Pinocchios. In other words, they say that was a lie. Quote, one of the biggest changes in the bill would expand early voting access for most counties, unquote. That's the Georgia Public Radio report on the Georgia voting laws. Quote, for most counties, you will have an extra weekend day and your weekday early voting hours will likely be longer. unquote. So in actuality, the Georgia voting law that President Biden claimed ended early voting actually did the exact opposite. It expanded these voting opportunities. Unfortunately, President Biden's repeating of the lie had rapid real-world consequences. You look at this with Major League Baseball. So this repeated lie caused the All-Star game in Atlanta to die. And I would have loved to have asked Senator Warnock, and probably will, how he will answer to his constituents for the loss of that game. And Ms. Abrams, I do have a question that I wanted to come to you on. When you've heard the comments, the repeated falsehood from the president that this is something that would hamper voting rights, and the comments about the Georgia law, does this hurt or help your cause for access for voting to more individuals?
With all due respect, Senator, to the Washington Post, I actually disagree with their characterization. For early in-person voting, 78% of counties already had more than the 8 hours of early voting. What SB 202 did was codify 9
All right.
to 5.
I don't mean to interrupt, but thank you. Thank you for that. Because I do have another question I want to go to Ms. Jones on. As I mentioned, I'd served on a voter, on an election commission. And my question for Representative Jones is about the voter rolls and the updating of the voter rolls. We took this as a very serious responsibility and worked hard at updating voter rolls. When you talk about the legislation that is being pushed, they would disallow counties to update their rolls. Therefore, mail-out ballots would go to people, as we saw in 2020, that no longer live in an area, or individuals that are deceased. And people saw hundreds of these on social media. So talk with me about how this process of going through and cleaning up these rolls adds and underpins the accuracy and the integrity in the elections.
Thank you, Senator. It is incredibly important to have so that you can have integrity in elections, that the voter rolls are not only cleaned up, but that there's also some security on the back end, because we did have voters receive multiple absentee ballot requests for previous occupants of their home or their apartment. And so that is why we also put the reasonable requirement in absentee ballots that they list their driver's license number or their free voter ID. And there's other provisions if they're one of the 2 or 3% of Georgians who don't have that. But the two go together so that we want every voter to cast a vote, and we want every legitimate vote to count.
Well, and that is imperative in preserving the one person, one vote rule, is making certain that the rolls are correct, so that only people who currently live in an area are able to vote in that state or in that county for those elections, so that you eliminate a lot of the voter fraud. Voter laws should make the elections more secure, and they should make it more difficult to cheat. That is how we preserve the integrity in the election system. And everyone entitled to vote should be able to vote. Secretary Gardner, I do have a question.
Senator,
I'm going to submit this to you. I'm going to submit, yes, sir.
I'm sorry.
I'm going to submit my question to Secretary Gardner because you've been generous with your time and the hearing has run very long. So, Mr. Chairman, thank you for letting me get a couple of questions in.
Thank you, Senator Blackburn, and Mr. Gardner will receive the question. I hope anyone who does receive a question among our witnesses will respond in a timely fashion. I want to thank the witnesses. This has been a 4-hour hearing, which is unusual in Senate Judiciary Committee, and is evidence of the interest in this issue as we expected. It is clear that we have work to do. The question is whether we will do something in a bipartisan way to restore the Voting Rights Act. We've been disappointed in recent years that the bipartisanship is gone. Perhaps, as hope springs eternal, that we can rekindle it. I want to thank everyone for participating. I hope that moving forward we can stand together in defense of our democracy. I want to explore with others in this Congress how we can do our part to protect the most fundamental right as Americans. This hearing will stand adjourned.